ये मैटरटा जोटा एंगेज करेगा नंबर 3 ना where is Mr. Sarangi? ତାଙ୍କୁ କହିଥିଲି ଆସିବା ବି ଆସିବେ ଆସିବେନି କେଉଁଥିଲେ ସେ କହିଲେ ମୁଁ ପେପର ହଁ ଯାଇ ତ ପେପରକୁ ରିସିଭ୍ କରିବା ପାଇଁ ଆମେ ସାର୍ ୱେଟ୍ କରିଦେବା ଟିକେ ଖାଲି ଜଣେଇଦେବା ହଁ ହଁ ଲେଟ୍ ହିମ୍ ୱେଟ୍ ହେଲା ଏଟାକୁ ଟେକଅପ୍ କରିବ ଏଟା ଆସିନାହାନ୍ତି କାଉନସିଲ୍ ପାସଓଭର କରିଥିଲେ ଠିକ୍ इंटीमेशन दे दी था मैं से था ऑनलाइन में थोड़ा ये करो हाँ ठीक है कम आइटम नंबर 2 दैट 1 sorry 1
Weekly list item number 1.
My lord. My lord, as far as the points formulated by Honorable Court, my lord, mostly it has been covered on our part, my lord.
No, it is up to you. If you want to
My lord,
close the argument, it's all right. If you want to proceed it further because it's a death reference,
my lord,
we are here to give you full opportunity.
my lord.
So anything you want to say. Number 2, you have to address also on the death reference. Suppose we hold that the charges have been grouped, then whether it would be a death sentence case or any other sentence.
That's point, my lord. My lord, on that point only I'll address on this point, my lord. Then my friend
about the death sentence.
Death sentence, my lord. Okay. As far as this case is concerned, my lord, that
let us go to the reasons assigned by the London trial court in imposing death sentence.
My lord,
that is which page of the paper book?
Hearing answer.
Achha, are they on the line? Please just take it. Okay, no, see you, sir. Okay, counsel is not there. See, just pachar.
नमस्कार सर
सर्कल जेल कोरापुट आपनकर गवर्नमेंट काउंसिल आसिलानी
ठीक है all right please
hearing on question sentence 281
camera off kar yes
page 281 my lord. May I place, my lord?
good. अरे डिस्टर्ब हो रहा You are Mr. Devasis Misra?
No, Himanshu Sandas.
Himanshu. Yeah. Idanya. Yes, which page you are telling?
My lord, 281.
Please. Proceed.
My lord. My lord. All the 9 convicts, that is,
Leave those names.
no,
Yes.
no, 53 point, they have been produced in court custody on special
Please
prosecution.
adjust the mic properly.
The learned special public prosecutor and the learned defense counsel are present. My lord, at 53.1, my lord, the learned special PP submitted that in his case, 3 persons of the family of the informant PW1, informant PW1 were murdered, the 2 females and 1 male, that is, the parents and sister of the informant PW1. In the first scene of occurrence, the convicts committed the offense in presence of the informant PW1, which she had fully witnesses.
Witnessed. Okay.
Witnessed, fully witnessed.
Hmm.
The manner in which the deceased persons were dealt with by the convicts is well founded from the testimony of the informant PW1 as well as our FIR Exhibit 1. The informant PW1 has categorically stated about the miseries undergone by her parents and sister at the first scene of occurrence due to the assault of the convicts and also administration of the pesticide to her sister by means of syringe on different parts of her body. It is also there in her testimony as well as in the FIR Exhibit 1 that due to such assault in her presence, the deceased persons were losing and regaining sense from time to time, and in moribund condition, they were shifted from the first place of occurrence to second place of occurrence, one after another, whereafter the deceased persons were no more found alive. The learned special PP further submitted that the father of the informant PW1.
No, but just pause for a moment. Due to such assault in her presence, the deceased persons were losing and regaining sense from time to time. It's all right. In a moribund condition, they were shifted from the first place of occurrence to the second place of occurrence.
Okay.
Where is that evidence?
Evidence nothing, my lord. Evidence means the second place means cremation ground.
No. Where is the evidence? I'm asking whether there is any evidence that they were shifted from the first place of occurrence to the second place of occurrence, or they were simply taken out from the first place of
Taken
occurrence.
out.
There is
Simply
difference.
taken out. That thing they are saying, but that from first place
There
to
is
second.
difference between the two.
My lord.
Okay.
Yes.
Yes. Next.
It appears
wrongly
that the prosecution case has been accepted as a whole.
Yes.
Perhaps
Yes.
considering the evidence,
Hmm.
the case is accepted by the court.
Yes. Next.
One after other, whereafter the deceased persons were no more found alive. The learned special PP further submitted that the father of the informant PW1 was sole owning member of their family, and after the death of her
Please take pause for a moment. Please take your seat. Mr.
Well,
Sarangi,
Yes, sir.
connect कर दिया संबलपुर सर्कल में. Keep that list, cause list. Who is to argue this item number? This 3 item numbers.
Rajesh Tripathi. Rajesh Tripathi.
No, please see that whether it is permissible for an additional standing counsel to argue a death reference matter or not.
Alright.
I think it is not permissible. Just take instruction and then. Okay. It is only the AGA or the GA, or either the AGA, GA, or Advocate General who used to. That is our. If it has been changed, we do not know. So death reference case is given a. He can argue even the simple
Life,
but so far as death reference, that is the precedence. So if it has changed, we do not know. Okay. So please show that on. So, Mr. Sarangi, we are engaging this appellant. That is a condemned prisoner, and obviously will be supplied with the paper book. And if you want to have any interaction at any point of time to know about something, you can just tell the registry so that they can make necessary arrangement. You can virtually have interaction with that man if you want after going through the any doubt, anything like that. And today you will be supplied with the paper book. How much time you want? Please show the paper book so that he just can have an idea. There are maybe one is the evidence, the and judgment. The other is maybe that any day next week. Next week you will be ready.
In any case, we are at serial number 1.
We are at serial number. We'll go to serial number 2.
Serial number 2.
Number
No,
3.
this item is serial number 3. So we are taking of serially.
Serially whenever.
We may take. We may start if it is possible. We'll start item number 2 tomorrow. So that is how we are proceeding. So just a minute.
The convict is also appearing through virtual mode.
Nabin Dehuri. ଆପଣଙ୍କୁ ଯୋଉ ଗତକାଲି କୁହାଯାଇଥିଲା ଯେ ଆପଣ ଯେତେବେଳେ କହିଲେ ଯେ ମୁଁ କରିପାରିବିନି ଆଡଭୋକେଟ, ଆମେ ଜଣେ ଏକ୍ସପିରିଏନ୍ସଡ ଲୟରଙ୍କୁ ଏନଗେଜ କଲୁ। ତାଙ୍କ ନାଁ ହେଲା ଦେବାଶିଷ ଷଡଙ୍ଗୀ। ଆପଣ ଦେଖିପାରୁଥିବେ ସେ ଆପଣଙ୍କର ପ୍ରେଜେନ୍ସରେ ଅଛନ୍ତି, ସାମ୍ନାରେ ଅଛନ୍ତି। ତାଙ୍କୁ ସେ ଆପଣଙ୍କର କେସ୍ ପରିଚାଳନା କରିବେ। ଯଦି ସେ କେସ୍ ପଢି ସାରିଲା ପରେ ପେପର ବୁକ୍ କିଛି ଆବଶ୍ୟକତା କରନ୍ତି ତାହେଲେ ସେ ଆପଣଙ୍କ ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା କରିବେ। ଅନଲାଇନ ଆମର ରେଜିଷ୍ଟ୍ରି ଆରେଞ୍ଜମେଣ୍ଟ କରିଦବ। ଯାହା ତାଙ୍କର ଡାଉଟ ଥିବ ଆପଣ ତାଙ୍କୁ କହିବେ। ତ ଆପଣଙ୍କର ଶୁଣାଣି ଆସନ୍ତା ସପ୍ତାହରେ ହବାର ସମ୍ଭାବନା ଅଛି। ଯେତେବେଳେ ବି ହବ ଆମେ ଆପଣଙ୍କୁ କହିବୁ ଏବଂ ଆପଣ ଅନଲାଇନରେ ରହିକି ଦେଖିପାରିବେ ଆପଣଙ୍କର ଶୁଣାଣି। ଠିକ ଅଛି। ଆଡଭୋକେଟ ନାଁଟା କହିଲି। ଆଡଭୋକେଟ ନାଁ କହିଲେ ନା କହିଦେଇଛି। ଦେବାଶିଷ ଷଡଙ୍ଗୀ। Take down that in pursuance of the order dated 23/4/2023. Put up? 2024. Correction कर दो। अच्छा correction कर दिया। लिखी दिया। Inadvertently in the latter part of the order dated 24/4/2024. It's totally wrong. What type of this was? Inadvertently in the latter order dated 24/4/2024, the date has been wrongly mentioned to be 23/4/2023. Finally can be. The date is corrected accordingly by scoring out 2, 3, TWO2 in inverted bucket 3, making it 4. Okay. There is 25th. No? After verifying the list furnished by the Register Judicial, we have decided to engage Mr. Devasis Sarangi as amicus curiae to conduct the case on behalf of the condemned prisoner Naveen Devuri. Mr. Devasis Sarangi is present in court today and he gave his consent to conduct the case
And also
accepted the paper books. And he submitted that we'll get ready by next week. Put up this matter in the
usual course.
usual course.
The matter is taken up in usual course.
The matter will be taken up in usual course. At any point of time, after going through the paper book, if Mr. Sarangi wants to have an interaction with the condemned prisoner, registry shall provide him and make necessary arrangement to in virtual mode,
for the same
through virtual mode. अच्छा ऊपर लिखी देवे the condemned prisoner oblique accused so and so appeared through virtual mode from Sambalpur Circle Jail, Sambal. So that's all. Just put your signature to have received the paper.
And he's also informed about the engagement of Mr. Sarangi.
The convict was informed about the engagement of Mr. Devasis Sarangi as his advocate. The name of Mr. Sarangi be reflected in the cause list henceforth in place of Ms. Vipali Mahapad. That's fine. Yes.
Second line, madam. The Learned Special PP further submitted that the father of the informant PW1 was the sole owning member of the family, and after death of her parents and sister, she being the eldest sister, two of her minor brothers are dependent on her, and they three have become orphan. This is a case which hinges on both the eyewitnesses' testimony as well as the circumstantial evidence, which the prosecution could well prove against the convicts. He further submitted that if the circumstantial evidence is found to be unimpeachable character in establishing the guilt of the accused, that forms the foundation for conviction, and that has nothing to do with the question of sentence, as has been observed by the Honorable Supreme Court in various cases while awarding death sentence. So, in such circumstances, this case comes within the category of rarest of rare cases, and the convicts deserve major penalty in such a case as well as the punishment for other offences for which they are charged. Then, my lord, it is submitted by the Learned Defence Counsel that convicts Dengun Sabar, Pradhantu Sabar, Dalsa Sabar, Malku Sabar, Lakia Sabar are orphans ever since their childhood, and they have been brought up by their respective relatives. He further submitted that convict Daswanta Sabara is motherless and unmarried, and the convict Ajanta Sabar has family burden. He further submitted that the convict Bubuna Sabara is a father of 6 children and he has heavy family burden, and the parents of convicts Iru Sabar are dead and his younger brother is CCL in connection with this case. He further submitted that the convicts are earning their livelihood by doing labor work and also depending upon seasonal forest products and they have their family burden. He further submitted that convicts have no criminal antecedent. Therefore, the learned defense counsel submitted that convicts may be dealt with leniently. The convicts, on being asked in the court, have pleaded their innocence and false implication. All of them prayed for leniency. In the instant case, the object of punishment is to be seen, which is punitive philosophy concerning social alarm. The infliction of punishment with a definite expression intends protection of society and stamping out criminal proclivity, and has to be achieved in the form of sentence. Law and its instrumentalities therefore should meet such challenges which are confronting the society and its safety. While imposing sentences, the court should not undermine the public confidence in the efficacy of law. It is therefore every court should bear the duty to award proper and adequate sentence, having regard to the nature of offences and the manner in which it was committed, and so on. The proportion between the crime and the punishment is a goal respected in the principles. The social impact of crime, where it relates to ghastly killings, including killing of women, has great impact on the social order with public interest and require adequate treatment. Any lapse in meeting adequacy in sentences may result in counterproductivity against the interest of the society. But special reasons have to be assigned while imposing sentences less than minimum or extreme sentence like capital punishment. In the instant case, it is to be seen as to if, in the given fact and circumstances of the case, imposition of punishment life imprisonment for the convicts is adequate, or it warrants capital punishment. As far as sentence for the offences under section 302 of IPC is concerned, the principle of law is that life imprisonment is the rule. It is worth to be noted here that all the murders are cruel, but unless the cases come within the ambit of rarest of rare category, the extreme punishment of death should not be imposed. Law is well settled that while going for the extreme punishment of death, the court is bound to give special reasons thereof. In state of Maharashtra versus Gorakh Ambaji Adsul, reported in my lord 2011 7 SCC 437, the Honorable Supreme Court have held as follows. The principles governing the sentencing policy in our criminal jurisprudence have more or less been consistent right from the pronouncement of the Constitution Bench judgment of this court in Bachan Singh versus State of Punjab, AR 1980, Supreme Court 898. Awarding punishment is certainly an onerous function in the dimension of criminal justice. The court is expected to keep in mind the facts and circumstances of the case, the principles of law governing award of sentence, the legislative intent of so special or general statutes raised in the case, and the impact of the awarding punishment. These are the nuances which need to be examined by the court with discernment and in depth. The legislative intent behind the enacting section 354(3) of CRPC clearly demonstrates the concern of the legislature for taking away the human life and imposing death penalty upon the accused. Concern for the dignity of a human life postulates resistance to taking a life through laws instrumentalities, and that ought not to be done, save in the rarest of rare cases, unless the alternative option is unquestionably foreclosed. In exercise of its discretion, the court would also take into consideration the mitigating circumstances and the resultant effects. The language of the section 354 clause 3 demonstrates the legislative concern and the conditions which need to be satisfied prior to imposition of death penalty. The words In the case of sentence of death, the special reason for such sentence unambiguously demonstrate the command of the legislature that such reasons have to be recorded for imposing the punishment of death sentence. This is how the concept of the rarest of rare cases has emerged in law. Viewed from that angle, both the legislative provisions and judicial pronouncements are at ad idem in law. The death penalty should be imposed in the rarest of rare cases, and that too for the special reasons to be recorded. To put it simply, a death sentence is not a rule but an exception. Even the exception must satisfy the prerequisites contemplated under section 354 clause 3 of CRPC in the light of dictum of the court in Bachan Singh. In Bachan Singh versus State of Punjab, AR 1980 Supreme Court 898, and also Machi Singh versus State of Punjab, AR 1983 Supreme Court 957. The Honorable Supreme Court have laid down the guidelines concerning aggravating circumstance and mitigating circumstance. In
So just you come to that inverted comma.
my lord, what's 39.
Yes.
The law enunciated by this court in the recent judgments, as already noticed, adds and elaborates the principles that were stated in the case of Bachan Singh and thereafter in the case of Machi Singh. The aforesaid judgments primarily dissect these principles into two different compartments, one being the aggravating circumstance, while the other being mitigating circumstance. The court would consider the cumulative effect of both these aspects, and normally it may not be very appropriate for a court to decide the most significant aspect of sentencing policy with reference to one of the classes under any of the following heads, while completely ignoring other classes under other heads. To balance the two is primary duty of the court. So it will be appropriate for the court to come to a final conclusion upon balancing the exercise that would help to administer the criminal justice system better and provide an effective and meaningful reasoning by the court as contemplated under section 354 clause 3 of CRPC. Then aggravating circumstance. The offences, first, what are the aggravating circumstances? First, the offences relating to commission of heinous crimes like murders, rape, armed dacoity, kidnapping, etc. by the accused with a prior record of conviction for capital felony, or offences committed by the person having substantial history of serious assault and criminal convictions. Second, the offences was committed while the offender was engaged in the commission of another serious offences. Third, the offences which committed with the intention to create a fear psychosis in the public at large and was committed in public places by weapon or device which clearly could be hazardous to the life of more than one person. 4. The offences of murder was committed for ransom or like offences to receive money or monetary benefits. 5th, hard killings. 6th, the offences was committed outrageously for want only while involving inhuman treatment and torture to the victim. The 7th, the offence was committed by person while in lawful custody. 8th, the murder or the offences which committed to prevent a person lawfully carrying out his duty like arrest or custody in place of lawful confinement of himself or another. For instance, murder is of a person who has acted a lawful discharge of his duty under section 43 of CRPC. 9th, when a crime is enormous in proportion, like making an attempt of murder of the entire family or the members of a particular community. 10, my lord, when the victim is innocent, helpless, or a person relies upon the trust of relationship and social norms like child helpless woman, a daughter or a niece staying with a father or uncle and is inflicted with crime by such a trusted person. 11. When the murder is committed for a motive which evidence totally depravity and meanness. 12th, my lord. When there is a cold-blooded murder without provocation. 13. The crime is committed so brutally that it pricks or shocks not only the judicial conscience but even the conscience of the society. Aggravating, my lord. These are will go to mitigating circumstances.
Just keep in mind the
Yes.
observation of the Honorable Supreme Court in different cases, particularly this number 3 and number 9.
Number 3 and 9.
Because the offense was committed with intention to create a fear psychosis in public at large. That you keep in mind.
My lord.
And number 9, when a crime is enormous in proportion, like making an attempt of murder of the entire family. So those two things just keep in mind.
Yes.
We want an answer from you. Is carry on the mitigating circumstances. Yes.
The manner and circumstances in and under which the offences were committed. For example, extreme mental and emotional disturbance or extreme provocation in contradistinction to all these situations like normal course. Situations in normal course. Second, the age of the accused is a relevant consideration but not a determinative factor by itself. 3. The chances of the accused of not indulging in commission of the crime again and the probability of the accused being reformed and rehabilitated. 4th, the condition of the accused shows that he was mentally defective and the defect impaired his capacity to appreciate the circumstances of the criminal conduct. 5th, the circumstance which in normal course of life would render such a behavior possible and could have effect of giving rise to mental imbalance in that given situation, like persistent harassment, or in fact leading to such a peak of the human behavior that in fact, in the facts and circumstances of the case, the accused believed that he was morally justified in committing the offense. 6th, 7, where it is absurd.
Circumstance. Age of the accused.
Age of the accused.
What is there in this case as mitigating circumstance?
Commission of such heinous crime. Broadly, these are the judicial discretion, but by attempting to make the excessive enumeration in one way or another, it is difficult to state absolute rule. Every case has to be decided on its own merits. The judicial pronouncements can only state precepts between the parties. Of the aggravating and mitigating circumstances, both aspects have to be two and see towards which side the scale tilts. The principle of proportion between the crime and criminal sentence, that is just. Thus, the courts should consider retributive and deterrent aspect of the punishment while imposing the extreme punishment of death.
Now we come to paragraph number 60. Because the principle there,
60, yes.
the cases which have
the
been
cases
discussed.
have been, yes, my lord.
Yes.
Yes, sir. As far as this case, instant case.
Yes.
The instant case is the case in which there are two spots of occurrence and 3 persons were killed by the convicts. Convicts. The first scene of occurrence had taken place at the place where the daughter of the two of the deceased and the sister of other deceased was present. The second scene of occurrence had taken place to which there is no eyewitness, but it completely rests on circumstantial evidence. So, this is a case on which the prosecution has relied upon the evidence of the eyewitnesses to the first part of the occurrence and upon the circumstantial evidence to the other part of the occurrence. As such, keeping in mind the above principles enunciated by the Honorable Supreme Court and also the facts and circumstances of the case in hand, it is now to be seen if the instant case comes within the scope and ambit of rarest of rare cases. 61. It is found that learned defense counsel is not in a position to point out any mitigating circumstance in the case in hand. In the present case, the convicts have killed 3 innocent persons, out of whom 2 were ladies, that is mother and elder sister of the informant, PW1, and the third one was the head of the family, that is father of the informant, PW1. Almost all the elderly family members of the informant, PW1, were done to death in the diabolical and dastardly manner. Fortunately, the informant PW1 was left, that too with a threat of dire consequences to her and also to her other family members, that is her 2 younger brothers, and they could be survived. In the present case, the convicts have killed 3 innocent persons of one family in such a cruel and ghastly manner that they first kidnapped the deceased persons Asina, Ambaya, and Asmani, confined them by tying against the stumps in the cowshed of Girjana, and when the informant PW1 reached at the spot on receiving information from the Damanta Sabara of her village, she was also tied by means of rope in the said cowshed against another stump. The convicts meted out cruelty to the deceased persons in the presence of the informant PW1. It is deposed by the informant PW1 that the convicts assaulted the deceased persons in such a cruel manner that they were not even listening to the request of the deceased persons to let them off. Let them off. Due to such assault, the deceased persons were losing and regaining their consciousness. The convicts even administered pesticides to the elder sister, that is another deceased of the informant PW1, by means of syringe on different parts of her body. It is further found that the convicts shifted the deceased persons one after another from the cowshed to another place, that is second place of occurrence, whereafter the deceased persons were found no more alive. But from the second scene of the occurrence, some charred bones pieces of the deceased persons could be recovered and seized during the investigation. In such situation, it will be nothing but a mockery of justice to permit the convicts to escape the extreme penalty of law when faced with such evidence and such cruel acts. It is required to be noted that the learned counsel appearing on behalf of the convicts is not in a position to point out any mitigating circumstances which does not warrant to come to conclusion that the case in hand does not come within the purview of the rarest of rare cases, and the convicts do not deserve the extreme punishment of death as provided under section 305 PC. Therefore, from what we discussed above, it is found that the aggravating circumstances are in favor of the prosecution and against the convicts. As such, the striking balance between the aggravating circumstances and the mitigating circumstances, this court is of humble view that aggravating circumstances will tilt the balance in favor of the capital punishment. In the facts and circumstances of the case, it is felt that there is no alternative punishment is left for convicts than the one which is death sentence. Now, coming to consider the possibility of the reformation of the convicts, there appears no material on record to justify the same. The theory of reformation cannot have universal acceptance because but it depends upon the facts and circumstances of each case. It is found from the testimony of the informant PW1 that she was so terrified that at the time she was unable to depose expressing her feelings by words and tried to express her feelings by action. It is found that during cross-examination with regard to miseries faced by the deceased persons and also by her sister due to administration of pesticide by means of syringe at the first scene of occurrence, the court recorded the evidence of the informant PW1 and remarked in brackets as the witnesses touched her right eye and said that those rolled on her cheek. Page 5, para 10 of Prosecution. To the query made through court, the informant PW1 replied that paragraph 24 replied at paragraph 24 of her evidence that we 4 brothers and sisters are no more residing in our village, apprehending danger to our life, and at present I am residing in my cousin's house at village Orasor under Putasing police station. It is also there in the testimony of the informant PW1 in paragraph 5 that the convicts had threatened her by deposing that they threatened me in the meeting that if I submit report to the police or give evidence in the court, it would not take seconds for them to kill me. And if they would be kept in jail, other villagers would not spare us. As such, the testimony of the informant PW1 shows that there is a danger to the lives of the informant PW1 and her brothers. Honorable Supreme Court, in the case of Machi Singh, have held that the reason why the community as a whole does not endorse the humanistic approach reflected in death sentence, in no case, doctrine are not far to seek. In the first place, the very humanistic edifice is constructed on the foundation of reverence for life principle. When a member of community violates this very principle by killing another member, the society may not feel itself bound by the shackles of the doctrine. Secondly, it has to be realized that every member of the community is able to live with safety without his or her own life being endangered because of the protective arm of the community and on account of the rule of law enforced by it. The very existence of the rule of law and the fear of being brought to book operates as a deterrent for those who have no scruples in killing others if it suits their ends. Every member of the community owes a debt to this community for this protection when ingratitude is shown instead of gratitude by killing a member of the community, which protects the murderer himself from being killed. Or when the community feels that for the sake of self-preservation, the killer has to be killed, the community may well withdraw the protection by sanctioning the death penalty, but the community will not do so in every case. It may do so in rarest of rare cases when it collective conscience is so shocked that it will expect the holders of the judicial power center to inflict death penalty irrespective of their personal opinion as regards desirability or otherwise of retaining death penalty. The future conduct of the particular man is assessed from his past and present activities, where these convicts have failed to justify. The philosophy of reverence and reformation is that one has to prospect his life by serving to the society. In the instant case, no previous good and noble activities of the convicts are forthcoming on record and brought to notice of this court by the learned defense counsel. Rather, the conduct of the convicts shows that they have committed the ghastly act by killing 3 innocent persons of one family, including 2 female, and instead of showing repentance, they also gave threats to the informant PW1 to kill her and her brothers. The learned defense counsel also could not place any matter before this court to convince with regard to the reformation of the convicts. Before concluding, it is worth mention here that in Lakshman Naik versus State of Orissa, year 1995,
come to that next paragraph
665. Thus, in view of the aforesaid discussions, this court is of humble opinion that in the instant case, life imprisonment would be inadequate sentence for the convicts. For the reasons stated above, the aggravating circumstances are outweighing the mitigating circumstances. The age of the convicts is within around 27 to 41 years. The crime is committed with extreme brutality that the collective consciousness of the society was shocked. Therefore, this court is of humble opinion that the case in hand comes within the rarest of rare cases, category of rarest of rare cases, and warrants the only deterrent punishment, that is capital punishment, that is death sentence, death sentence. Accordingly, this court passes the order of sentence under section 342, 364, 65, 302, 201, 506, read with 34 of IPC, 34 of the Indian Penal Code, read with section 4 of the Odisha Prevention of Witch Hunting Act 2013 against all the 9 convicts. Names are there, my lord, and they are convicted as follows. The convicts, that is Dengun Sabar, is 9, my lord, as sentenced to death for the offences punishable under section 302, read with 34 of Indian Penal Code. Accordingly, each convicts, that is convicts abandoned, be hanged by neck till they are dead, subject to confirmation of the same by the Honorable High Court. The death sentence shall not be executed till the same is confirmed by the Honorable High Court. And the convicts shall also pay fine of 40,000 rupees each in default of payment of fine. The convicts are further to undergo rigorous imprisonment for 2 years each.
So the rest of the punishment we have seen.
Yes,
for 302 by 34 of the IPC, death sentence has been imposed.
My lord.
The reasons have been assigned. So let us say, for the sake of argument, this court accepts that the evidence which has been adduced, not only PW1, whatever evidence has been adduced by the prosecution, including PW1, is sufficient to hold the petitioners or the condemned prisoners guilty of these offences. So what is your submission that no, it will not come within the rarest of rare case? So therefore, death sentence should not be imposed in. What is your submission?
First ground is ballot.
Yeah.
Let us entirely accept it, but if the entire evidence is accepted and it is comes by the conclusion that it is against all the 9 appellants, my lord, under section to make out under section 302 of IPC, my lord. Your lordship will see the circumstance what it is narrated by the prosecution.
You are again going to the merit of the.
No, not merit, but you will Then I'm not going to the merit, my lord, just pointing out.
You have to address
only one line I will point out.
Yes.
What
if you want to address on merit, there is no problem.
No, we will not
You
take.
said that we will not. You said yourself when we stated that whether you want to address any further, you said no. I will confine only whether it
Only
is
one point.
Right.
Only one point means the circumstances that playing a witchcraft. So what to be narrated by the prosecution, that is playing up witchcraft.
No.
Superstition.
Multiple murders have been committed suspecting the deceased persons
playing witchcraft
activities in connection with the witchcraft. Right?
Yes.
So in such a case, whether death penalty should be imposed or it would be a life imprisonment. If we accept that at all the prosecution has been. Somebody is committing multiple murder or these accused persons for suspecting these activities. And let us say whatever the aggravating circumstances that has been enumerated, we pointed out you 2 things. This number 3 and number 9. It's a multiple murder. It's an attempt to murder the entire family. Of course, one has been spared here. And the other thing is to create a fear psychosis in public at large. So these two things, how do you say this is not meted out? Number one.
Yes.
Number two, how do you come, whether you come under any of the mitigating circumstances that has been enumerated in page number 130 and 131 of the judgment. हाँ जोटा कि 288 और 289 except we pointed out that there may be that number 7 is somehow rather helpful to you. So how do you meet it? Multiple murders for this suspecting the involvement of the deceased persons in the witchcraft activities, for which some persons have died in the village or some persons have fallen ill, that this is they took it that it was due to the witchcraft activities, and that is how multiple murders have been committed, 3 murders.
Yes.
And out of which 2 are ladies.
2 other ladies, yes.
So if this is the prosecution case and it is held that whatever direct or circumstantial evidence has been brought on record, the offences are proved, then what is your submission?
Well, from the my lord, from the story, my lord, it has been as far as witchcraft is concerned. If the witchcraft, that is a one form of a superstition, my lord. That is a one form of superstition, my lord. On the superstition belief one has done, my lord, his mind, they are suppose they have accepted that they are believing on the superstition, my lord, or witchcraft, they are believing. So their minds are pre-arrested, my lord, pre-arrested. So what I submit, that this is not a cold-blooded murder, because on that mind or the motive to kill, my lord, if they are arrested on the superstition, my lord, so that cannot be said as a cold-blooded murder.
Have you found a single decision on this? That of witchcraft activity, somebody is suspecting the deceased person's involvement in witchcraft activities, and for that the multiple murders have been committed, you may get the decision otherwise against you.
Superstition
re witchcraft activities jogu multiple murders committed, that would be a ground for death penalty. You may get decision against you. There are a number of decisions. Yes. Have you tried to find out?
I'll find out. Today I will give.
Because let us say child sacrifice case, in which the murders is committed for getting some property or some power.
Yes.
So that those are also held to be rarest of rare case. Yes. And let us say this rape and murder of a child, these have been held also to be this type of cases that they have stated that how. So here, if it is believed or accepted, or the prosecution is projecting the case that these murders were committed because of this particular reason, and this court accepts, then in such circumstances, whether it would be a death sentence or life imprisonment.
I'll clarify this.
We are giving you just Mr. I'm giving you clue. If you have Manu search, just type it out. Multiple murders, superstition,
sorcery,
death. Just click this sex. You will get number of decisions of the Supreme Court also. Multiple murders, superstition, death sentence. एतिको click कर देबे अपन पाई जिवे से case, हला? It's not that this type of case is coming for the first time to.
Yes. Number of cases.
Okay. Why this particular act came into force because of these things.
Superstition. Yes.
This Orissa Prevention of Witch Hunting Act, it in different states also similar acts are there. So that has been framed because on say this superstitions, number of crime has been committed. So when it is connected with other crimes like multiple murders, the court has taken it very seriously The Supreme Court and some of the high courts taken it very seriously, and they have categorized it to be the rarest of rare case. So that also you have to keep in mind, study what is the and how. Yes, even if it comes within any of the mitigating circumstance. Matter is
That
different.
will balance.
That's
Somewhere
a
balance.
different. Okay. So that is to be also taken into account, keep in mind. If you are not prepared on that,
And in the 3, my lord, that is page 287.3, that so the intention to create fear psychosis in the public at large.
Actually, superstition is a belief
Belief.
which has triggered the convicts to commit the crime.
Yes.
It cannot be the basis to claim as a mitigating circumstance when there has been multiple murders.
Yes,
Visible, though?
You're correct.
So kindly examine it.
But as far as my lord, page 227, my lord, aggravating circumstances, my lord. But it says 3, the offences was committed within the intention to create fear psychosis in the public at large, my lord. Here, lordship, public at large.
ଆପଣଙ୍କର ଏଇ ଟାଇପ ର ଯଦି ଜଣେ କ୍ରାଇମ କରିବ ଯେ ଯିଏ ବି ସେମିତି ଇନଭଲଭମେଣ୍ଟ ହବ ପବ୍ଲିକ ରେ ତାଙ୍କର ଏଇ ଦଶା ହବ ଯିଏ ବି ଏଇଟା ହଉଛି ସେମାନେ ଗୋଟେ ପବ୍ଲିକ କୁ ଜଣେଇ ଦବାକୁ ଚାହୁଁଛନ୍ତି ଦି ଆକ୍ୟୁଜ୍ଡ ପର୍ସନ
ଯଦି କିଏ କରନ୍ତି ସେମିତିଆ ତେଣୁ you will face the same consequence.
So that is the offense was committed with intention to create fear psychosis.
That is lacking here. Here, my lord, in this case, my lord, particularly in this case. गोटे पब्लिक मध्य केही कहउनांती माने से एस्पेक्ट ऊपर कोनसी भी कहउनांती के मतलब now we are in the last page. Yes, now we are in the last page because we are accepting that everything is correct and that is against all the accused persons. That is why
obviously when we are this is an last argument माने हमें we quote that we accept the evidence.
Yes.
Then whether it would be a death sentence or life imprisonment सेही point रे आपण argument start करछिन
हां ठीक अछि
तेणु appreciation को वर्तमान बैक करंतुनी you complete it on this point death sentence you may say that we have something left out you can argue there is no problem in that
will not argue
we are here to give you full opportunity because 9 persons have been sentenced to death so we there is no chance of any hurriedness we are giving you patient hearing so there is no problem in that so again we are telling that we are hinting out that you may get some decisions that in such type of cases where multiple murders committed for superstition, then it would be a ground to impose death sentence. Okay. So that you find out and see the analysis which has been made by the Supreme Court or other High Court and try to collect those decisions and place it. That would be.
You are also to weigh the balance between the two, aggravating and mitigating. And the circumstances which have been narrated in the judgment are illustrative in nature. That is not exhaustive.
Not exhaustive.
Keep in mind.
Yes, madam.
Any Mr. Das, just before he continue, we just want to know that so far as the number one aggravating circumstance here, it is mentioned that if they have any criminal antecedent like previous conviction, then that is also one of the ground. So I think from the record, from the judgment, nothing is so prosecution has not come forward that they have got any criminal antecedent or like that. That is not there. Okay. Yes. On that particular point, if you are not prepared, then
prepared, my lord.
You can give the citations tomorrow. There is no problem. My lord. So we can hear Mr. Chand and Mr. Das also. We can hear. And only this is so far death sentence. Have you left anything on the merit of the case to address? You have completed your answer. Okay. Please take your seat. Mr. Chand.
State has to answer the contents which
so he has raised its contention because yesterday you were not there, your associate was there. You prepared. He said we have also noted down. No, anything we gave you an opportunity that anything you want to say either on merit or on death
Yes,
sentence,
my
you can say. Then, of course, Mr. Das will argue.
I have also taken note of the submission which has been advanced by my friend as well as the State Council. And yesterday, my lord has also forwarded certain points. I have also seen it through live streaming. I have seen, my lord. One thing I want to add, FIR, my lord. Now, my humble submission in the particular fact and circumstance, the FIR is, my lord, a planted one and antedated one. As per the prosecution, the Procedural one went to the police station on 16/9/2016 at about evening hour, because it is horse evidence that after coming to know about the cremation of the body, after being dug out from that particular burial place, it reaches to information on 15th, and accordingly she lost the affair on 16th evening, my lord. And it is the affair where it has been specifically said the name of 10 persons to be the assailant, because affair clearly says that these 10 persons are the person who have allegedly committed the crime. So my humble submission, after this affair was registered on 16/9/2016, my lord, on 17/9/2016 at about 12 in the afternoon, this process of spot visit started. And this process of spot visit, as per the Procedural 11, my lord, it is that based on a requisition made by him to the SP as well as the concerned executive magistrate, both reach the spot, and from 12 noon onwards, the spot visit starts, my lord, by the in presence by the science that forensic lab experts, my lord. This particular spot visit, my lord, specific to this extent, I will show the wages, my lord, to specific to the extent that the villagers, some persons and villagers are the person who have committed the crime. Nowhere it speaks about the name of any person, or nowhere it speaks give the clear name of the assailants who have committed the crime.
In the spot visit report, you are saying.
My lord.
So what is that spot visit report? That is exhibit?
That is, my lord. It starts from page exhibit 19, my lord, 19. It's page, my lord, 341.
Please come to that line.
My lord.
Let us see that.
Page 341, exhibit 19, my lord. Spot visit report, my lord.
Wait. Yes.
Volume number 2. And it's from serial number 1 is the serial number 3516. Puta Singh PS case number such and such, dated 16/9/2002, wherein offense has been registered. Also,
No, yes, we followed it. That in column number 7,
exactly,
it is mentioned like this.
With description of the scene of crime, details description of the dead bodies and injuries.
Okay, it is mentioned that it was reported at the
police
PS by so-and-so,
daughter of such and such,
that on so-and-so some villagers murdered her family, and after getting, you mean to say that whatever information was given by PW1 in the police station before this, prior to the spot visit, that was against some villagers, but not named against
persons, specific persons.
Otherwise, it would not have been mentioned as some villagers. The names of the accused would have been there. That is your submission. And there is every chance that another report, which containing the names of the accused persons, have been subsequently lost, planted, concocted, and that has been treated as FIR.
Exactly.
So the original first information report
has been suppressed. The same page, my lord. The second para.
But one thing you must answer, that this spot visit report indicates the case number. That is Puta Singh PS case number 17, dated so-and-so, under section also so-and-so. That is, so a case by then has already been registered.
I don't
if your submission is accepted, then what do you mean to say that by the time this spot visit was made, no case has at all been registered?
No,
because some kind of information was given that some villagers has committed the offense. So obviously, if any written report or oral report was given, so the case was not registered by then. The case was registered only after the spot visit was made. So
No.
if that would have been the correct state of affairs according to you, then how did the
Yes.
PS case number? Then obviously this number has also been subsequently inserted.
My humble submission, it is the specific evidence of PW 11 that based on the requisition made by him to the concerned SP, as well as with a prayer for deputation of the executive magistrate, the executive magistrate reached the spot along with this FSL team who have made the spot visit. So I cannot deny at the present stage that there was no affair. My humble submission, there was a affair based on which he has made the requisition. And admittedly, in the evidence he has said, PW 11 has said that he has not seized the requisition. And therefore also he has said the requisition has been sent to SP.
No, just take pause for a moment. If you say that there is one FIR prior to the spot visit, then who lost that FIR? The FIR has been given by that Melita Sabar.
I'm meeting the Honorable Court's query, my lord. PW 9 being the relation, the maternal uncle of the deceased, the informant, PW 9, it is his evidence that on 16/9/2016, I had been to the police station and police also taken some signature from me. That is admitted in the evidence. So if that is so there is one information, and the same PW 9 also in his evidence said that it is the villagers who have committed. It is also his not evidence that these persons have committed the crime. So my humble submission that there was an affair, perhaps because of the fact all sorts of circumstances, it was lost by the information was reached before the police station by PW 9. And that part also, my lord.
Who according to you had given the first information which has not seen the light of the day? We are putting it in this way.
Yes, my lord. In such a case, my humble submission, it is none other than PW 9.
PW 9. But PW 1 says that I accompanied the scribe of the FIR and
I think PW 7.
PW 7.
Sir, it's a report prepared by the scientific officer.
My lord.
DFSL. So why so much of emphasis?
My humble submission, because I'll appreciate. Before all such things was there, because
he has just narrated that such a report was received by the IO.
My lord.
And a case was registered, and this is the case.
No, my humble submission, I want to harp it upon.
And he has collected all the physical clue.
My lord. I want to harp it upon strenuously on this ground.
It is material.
He is harping on that. You are harping on these two words.
It's not a report by the IO.
That some villagers. According to you, the scientific officer should have also mentioned the names of all the accused persons instead of some villagers. In case an FIR of this nature has earlier been lost. That is your submission.
And to 45
there's no need for the scientific officer to mention all the names.
And the scientific officer has also not been examined.
And the purpose is to collect the physical clue, sir.
No, I don't dispute that, madam. My humble submission based on information, because the scientific officer went there on the requisition made by the concerned investigator or the concerned IIC. Admittedly, that is the case, because it is his evidence that I sent the requisition to the SP, who has passed on to the concerned scientific officer. Besides, I sent the information to the concerned executive magistrate for his presence for this particular purpose. And pursuant to that, my lord, both of scientific officer is there, besides the executive magistrate. So he has also admitted that he has not seized that particular in requisition. And he has also said that he has also not seized the message which has been sent to the particular things. So my humble solution, taking advantage of that particular things, this affair which was earlier there, it has been manipulated or
how do again we are asking you that how do you say that no, somebody like PW9 is actually the person who has lost the information report earlier prior to PW1? You said, na?
Yes, madam.
We said
that
whose report has been suppressed. You said it is the report of PW9. Right? So on what basis you are telling that PW9...
Whether such a question was put to the IO in cross-examination that
Malad-
the FIR was planted,
No, that is not. that.
antedated?
Then
Then, sir,
not only that, you should have also to put to the that informant also, that whatever report is have you put any question first at all to this whether he has stated like that I have lost any report?
No, PW9.
PW9 କୌଣସି କହିଛି କି ମୁଁ ଥାନାରେ report ଦେଲି?
I went to the police station and he has signed.
Please come to that.
PW9 pays my lord
127.
127.
କୁହନ୍ତୁ ଆପଣ କୋଉ ଲାଇନଟାରେ ସେ କହୁଛି ମୁଁ ପ୍ରଥମରେ ଯାଇ ରିପୋର୍ଟ ଦେଲି
Sorry,
ବା ଆପଣ ତାକୁ
120
ସଜେସନ ଦେଇଛନ୍ତି?
128 my lord. Para 8.
128
Para 8 my lord.
ହଁ
As I faintly remember, I had gone to Putasing PS on 9th September 2016, much prior to this, my lord. Much prior to lodging of paper, my lord. I had gone only one to the Putasing PS and not on subsequent day. I cannot say the content of exhibit such and such. I am unable to read and due to low vision, I might have signed on 1 or 2 pages as I failed to recollect it, my lord. So if that is there, my lord, so information was admittedly with the particular police station. And also, my lord, may take note of this. Also, my lord, may have a glance to the evidence of this IO.
no just it is to be read along with paragraph number 2.
My lord.
If we read it along with paragraph number 2,
Conjoint reading, my lord.
and he has visited the police station only once,
My lord.
and he has stated that what has happened in that visit. He said on that day these two persons confessed before so and so that we have killed so and so. So obviously those two persons came to the police station after registration of the FIR,
No,
after they were arrested, not prior to that. So here is the question of on 9th he is going to police station and the accused persons remaining present there for making confession. Good chief re କହୁଛି ମୁଁ police station ku ଯୋଉ ଦିନ ଯାଇଥିଲି ସେଦିନ 2 ଜଣ accused confess କଲେ ଯେ ଆମେ ମାନେ ମାରିଛୁ ଏମାନଙ୍କୁ ଏଇ 3 ଜଣ। କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛି ଯେ 9 ତାରିଖ ଦିନ ଗୋଟିଏ ଥର ମାତ୍ର ମୁଁ police station କୁ ଯାଇଥିଲି। ତ ଏ ଦିଟା ଯାକୁ ଆମେ simultaneously read କରିବା। ଯଦି read କରିବା ତାହେଲେ 9 ତାମାନେ 9 ତାରିଖ ଦିନ ଯୋଉ ଦିନ ସେ ଗଲା ସେଦିନ 2 ଜଣ ଯାକ accused arrest ହେଇ ଥାନାରେ ଥିଲେ ଏବଂ ସେମାନେ ଆ ପ୍ରେଜେନ୍ସ ରେ କହିଲେ ଯେ ଆମେ ମାରିଛୁ ଏୟା ତ। କିନ୍ତୁ whether it is at all the prosecution case that on 9th any of the accused person, there is nothing on record that anybody was suspected on 9th itself. Question of appearing in the police station making confession does not arise. ଘଟଣା ହେଲା 9 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟା ବେଳେ ତେଣୁ ଇଏ police station କୁ ଯାଇକିନି ପହଞ୍ଚି ଗଲା ଏବଂ ତା ପାଖରେ 2 ଜଣ accused ସେଦିନ ରାତିରେ ବା confession କଲେ, it does not correlate with each other.
And in such a circumstance, I pray to have a glance to page 140.
And he has also not been asked as to why had been to PS on 9th September.
That part is lacking, my lord. I cannot improve all these things. That is there.
And he also that not.
Which
time he has gone there?
Why? What was the purpose? There has been no question.
When some link is coming out, it is the
faintly remember I had
not exactly.
One thing is that he said that I had gone only once to Putasing police station, not on any subsequent date. So this question might have been put Mr. Das with an intention that if he had gone to on 9th only
Then
and not on the 7th, then what he is telling about this confessional statement of the co-accused persons, all these things is
The
not
occurrence took place on 9th September.
9th
evening.
Evening.
There's no time mentioned.
No time mentioned.
If the occurrence is taking place in the evening, what was the purpose for PW9 to visit the PS on the same date? At what time?
What time?
There's no clarity, sir.
My humble submission, because of the fact the prosecution has developed the case from by one after the other, and at each and every aspect the PW1 has developed. So the date of occurrence, as has been alleged,
And also
may not be there on this
No,
relative
it
date.
should have been brought out from the mouth of PW9.
Yes,
What was the reason why he had been to the PS on 9th?
My humble submission
that
is
is not
that
there.
because things has come up to this stage, and when he has given some clue, it is the duty of the defense counsel at the relevant time to get some more from his mouth, but that is not there. That is not there. I cannot, my lord, improve right now. Whatever is available, I am trying to impress upon my lord to that the FIR which was given at the first instance, or the information which was available to the police, is not the one which is now before the Honorable Court as PW as
It's
the
not been suggested to PW1, not been suggested to PW9, not even to PW11.
Right.
IO.
IO suggested.
no IO could ହେଇଛି ଆଜ୍ଞା
IO କଣ
my
ହେଇଛି?
lord may see page
ଆଉ
1
ଗୋଟେ FIR ଦିଆ ହେଇଥିଲା
ସେଟା ନାହିଁ
ଆଉ ତାହେଲେ
ସେଇ ପଟ exactly
ଗୋଟେ
Before
written
going to
report
that, my
ଦିଆ
lord, can I have a glance on para 10, my lord? Para 10.
para 10 କାହାର?
Say PW9,
ହଁ
1 to 9 page. I had not seen the incident myself,
ହୁଁ
nor I possesses any personal knowledge about the occurrence,
ହୁଁ
bearing the fact being confessed by the accused person seizure. So if he has no knowledge about the occurrence, so why he will go and report the how he will go and report the thing before the police? He has gone on 9th. What time is not mentioned? What is the sequence why he went to there?
କାରଣ ଆପଣ ଦେଖନ୍ତୁ ଲଟା ହଉଛି ମିଷ୍ଟର ଚାନ୍ଦ ଦି ଲ ଇଜ ଭେରି କ୍ଲିୟର ଯେ ଆପଣ ଯଦି କହିବେ ଯେ ଆଇଓ ଡିଲେ କଲା ଡେଲିବରେଟଲି then specific questions should have been
to
should
that.
be put so that he may explain it that why you ଖାଲି କହିବା ଆଜ୍ଞା 9 ତାରିଖ ଘଟଣା ହେଲା ସିଏ 12 ତାରିଖ 13 ତାରିଖରେ ରେକର୍ଡ କରିଛି ତେଣୁ ଏଇଟା ଡେଲିବରେଟଲି ଏଇଟା ଆରେ ସିଏ ହୁଏତ ଲ ଆଣ୍ଡ ଅର୍ଡରରେ ଥିବ ଅନ୍ୟ କୋଉ ଇନଭେଷ୍ଟିଗେସନ କେସରେ କରୁଥିବ ତାକୁ ଆପଣ କହିବେ ହଁ କିଛି କାମ ନାହିଁ 9 ତାରିଖରୁ ରହିଛି 12 ତାରିଖରେ ରେକର୍ଡ କରିଛି ଆଉ କିଛି ତାର ଇଏ ନାହିଁ ମ୍ୟାଟର ଇଜ ଡିଫରେଣ୍ଟ so that is the reason why the decision says that you must put question
to that
that why if the witnesses are available and you started your investigation on this particular day then why these material witnesses were examined on that day so if you not put the question just take a ground that they have been examined at a belated stage so it is all planted it is all concocted that cannot be accepted. So here, your submission, as we find that PW9, since he has stated that he visited the police station on 9th, and that too only once, not thereafter, and he's making a statement in the cross-examination that two of the accused person confessed in his presence. If on 9th, the case has been not registered, and the accused persons were not arrested, the question of hearing confession from them on 9th is not acceptable. That can be said in that way. So it may be argued in that way. That's a different matter. But that about that FIR was suppressed, and that too merely because the scientific officer has mentioned something. That is how far.
Unless there is a case made out, we can choose the lines from the evidence of PW line and with reference to the spot visit report to claim that the FIR was planted.
Yes, my humble submission.
Case has to be specifically made out, sir.
Spot visit report is the preparation of the report based on the acquisition and based on the materials and based on the person who have allegedly, because it's the spot visit report before going to the spot, it is definitely in the mind of the concerned scientific officer about the exact story, who are the persons, how many persons, and who are the victim, all such things, because then only they can when they will reach the particular spot, they will explore that things, and by the process they may collect something. So my humble submission, definitely it was in the mind of the concerned person, the villagers, not any specific person have committed the crime, and that is the reason for which none of the name of the assailant has been reflected in the spot visit report. That is my submission be subject to acceptance.
Because such type of submission is also made when in that column 9 of the inquest report, the names are not mentioned. It is sometimes mentioned ଯେ ଯଦି ଇନଫର୍ମେସନ ଥିଲା ଆକ୍ୟୁଜ ଯିଏ ଥିଲା ତାହେଲେ କଲମ 9 ରେ ମେନସନ ହେଇଥାନ୍ତା ତେଣୁ ଏଥିରୁ ଜଣା ପଡୁଛି ଯେ ଏଫଆଇଆର ସେତେବେଳକୁ ଏକ୍ଜିଷ୍ଟେଣ୍ଟ ନଥିଲା ନା କେହି ଜାଣିନଥିଲେ ଇନକ୍ୱେଷ୍ଟ ପର୍ଯ୍ୟନ୍ତ ମଧ୍ୟ କେହି ଜାଣିନଥିଲେ ଆକ୍ୟୁଜ କିଏ ଦିସ୍ ଇଜ ଦି but the honorable supreme court said that it is not the that relevant portion of that particular column does not indicate require to mention the name of the accused persons it just say the circumstances under which କୋଉ ଭଳି ଭାବରେ ଇଏଟା ହେଲା ତାର ୱିଟନେସ୍ ମାନଙ୍କର ଓପିନିଅନ ପାଇଁ it is not necessary at all to mention the names of the accused persons in column number 9 of the inquest report and merely because it is not mentioned the prosecution case cannot be disbelieved, or the FIR cannot be disbelieved, and it cannot be said that there was no existence of the FIR by then. So that is the thing. ତେଣୁ ମନେ କରନ୍ତୁ ଗୋଟେ in a case of rape, and in the medical report it is mentioned that it is reported that the victim has been raped. The accused name is not mentioned. Then can it be said that prior to the examination of the victim, there was no information with anybody that this man was involved in the commission of rape, merely because the medical officer, while preparing the report, has mentioned that it is reported that rape has been committed. He has not mentioned who is that man committed. So these are all the things addressed, but it is to be seen that other things are entire as a whole the case, it is to be seen some other agency, though they are linked with the investigation, but somebody else is investigating the case. He is registering the FIR. He is preparing the statements of the witnesses. The scientific officer's role is something different, as has been pointed out by my esteemed brother, that they are coming to the spot for a particular reason. They are to collect whatever the evidence, they are keeping it, and here they are to just hand it over to the IO so that it will be forwarded for FSL for preparation of the C report. So their role is very limited. So why they have not mentioned the names of the accused, and from that it is to be inferred that by that time, so that is still yes, you can proceed.
One more thing I want to add to establish my stand, Malad, here, as I have pointed out, Malad. That is page 140, evidence of PDO 11. FIR was received on 16/9/2016 about 7:05 p.m.
Which where you are placing?
Malad, page 24, sorry, page 140, para 24, Malad, PDO 11. See, same stand that FIR is a planted one after this 70, Malad. FIR was received on 16/9/2016 at 7 p.m. That is 7 days after the occurrence. That is 9/9/2016. In between the gap of 7 days, no information at the PS had this reached regarding the occurrence to the best of my knowledge, but I had joined on 14/9/2016 at Putangi PS on my transfer till filing of FIR. The incident had not come to my notice. It is not a fact that on 11/9/2016 the occurrence was published in daily newspaper and also had been televised by some news agency. I cannot say if I had skipped my notice as I was availing transit after being relieved from Sexpal PS. As I remember, I had joined Tracing PS on 13/9/2016 evening, not on 14/9/2016. Sub-Inspector Rasmi Ranjan Das was heading the PS of OIC as inspector of that PS was transferred. I had not examined SI SRR Das in connection with this case to ascertain if prior information concerning the occurrence was available with him.
No, ଆପଣ ଗୋଟେ ସଜେସନ ଦେଲେ ଯେ 11 ତାରିଖ ଦିନ ଏ ଘଟଣା ନ୍ୟୁଜ ପେପରରେ ବାହାରିଥିଲା ଏବଂ ଇଭେନ୍ ଇଫ୍ ନ୍ୟୁଜ ଏଜେନ୍ସି କିଛି ନ୍ୟୁଜ ଏଜେନ୍ସି ତାକୁ ଇଏ କଲେ, ସେ ମ୍ୟାଟେରିଆଲ ଆପଣ ରେକର୍ଡକୁ ଆଣିଲେ କି? ତାହେଲେ ସେ ତ ମନା କରୁଛି, କହୁଛି ନାଇଁ ମୁଁ ଜାଣିନି, କାରଣ obviously he was there not in that police station.
No,
he joined on
14th.
So 11 ତାରିଖରେ ଯଦି ଏମିତି ଗୋଟେ ଲୋକାଲ ନ୍ୟୁଜ ପେପର ଏମିତି ବାହାରିଛି ଏବଂ ନ୍ୟୁଜରେ ମଧ୍ୟ ଆସିଛି ଯେମିତି ଗୋଟେ 3ଟା ମର୍ଡର ହେଇଯାଇଛି, so it is expected that it should have been brought to the notice of the police.
Paper clipping also. And to my instruction, in the meantime, the co-convict, a juvenile, he has been acquitted by the court below.
No, acquitted man ତା ଦେହରେ କ'ଣ ହେଇଥିବ, କୋଉ evidence ଦିଆ ହେଇଥିବ? If you would have,
I have already applied for. I have already applied for this certified copy all the deposition. Wherein also the federal one has taken a different stand. That is my instruction. It's because I have not yet received those documents. I am not in a position to.
Then why are you making so late? You see, if she has given on oath on a totally different version, you can file an application for taken as an additional evidence.
That is the reason I have already applied for, because
unless we do not know that nothing is brought on. One thing you are submitting from the beginning, that one of the a juvenile who was facing that inquiry or whatever it may be, he has been acquitted. We asked also, I think, asked him that whether you have a copy of this judgment. He said no. So
I have already applied for within a day or two. I'll get it. All sourcing document.
it's a very serious matter.
Well, yeah, that's why I'm not in a position to give a clear picture to the court. And unless only like, and as per the instruction, she has totally give a U-turn to the particular case. That's why the learned juvenile court has acquitted him. The juvenile, the CCL.
When the said judgment was delivered by
2 years back.
2 years back.
And my lord may see the entire judgment
prior to the judgment of this case.
Yes, yes. The particular case, twice judgment was
no, Mr. Chan, if PW1, we do not know when he deposed in court in that juvenile case. Suppose he has deposed earlier and giving a total different story, then whether it was not necessary on the part of the Learned Defense Counsel to confront such previous statement that upon a case Sankrantare would a juvenile. It was required and to prove also that. And of course, at this stage, you can, but the thing is that you must bring that material.
That's why I
want any kind of.
Just make a submission. In the year 2018, the first judgment was there. In the year 2021, the second judgment was there. So in between, these things has happened. So it was definite duty of the concerned defense counsel.
This judgment is dated 21st October 2021. When that judgment was delivered?
Around 20. It is there as per
20. Why then the trial was in progress?
Yes.
Why it has not been confronted?
See, remand if he has given a totally different story.
No, we do not know what is the.
No, he says that. That is why I am saying that. Mr. Das, have you got any information?
No, madam.
No, for interest of justice, why? Because it's a death sentence case, and your sole witness prior to the remand of the case, while the death reference was here, he deposed in that very particular case in respect of co-accused. And if he gives a total different story, and if he, then that is certainly has got some relevance. Maybe that the counsel was not properly instructed that.
Right. Or my lord may also call for, if I'll call for the.
No, you are not giving what is that number, what I,
after launch, I'll provide everything.
Provide that number that can reach here by 4 o'clock. It can reach, the entire record can reach. You will send it by email. What is there? There is no problem in that.
But if the version is similar, and there is a contested disposal,
right, that is.
And we are not bound by the judgment of the decision.
I am not under that. Because
it can differ also.
Obviously, I am not saying. My humble submission, because the fact that confront him. And as I have this point.
But you are sure that that juvenile has been acquitted? Okay.
And
all right, please proceed.
We are following this process only to avoid the conflict in decision.
Okay, madam. Yes.
That's all. But not bound by the judgment of the judges.
And if my lord found that.
And in any case, it has not been confronted to PW1 during trial.
But my lord may also
that should be borne in mind.
In such a case, if that will be there, because my lord may also take note of judicial notice, and can also take
care of only option available is under section
additional
391 is there. So for that, the other exercises are to be made so that
for a limited purpose.
For this limited purpose, it has to go to that code, he has to confront it, then again come here. We can assess the matter is different. But unless the bases are there before us, that's
obviously.
So
obviously.
Yes.
And as I have pointed out, my lord, this particular, although that was there, and this was this aspect has also not been taken care of, this publicity, although it is also my fault. I do consider the fault lies on the defense, because had there been such telecast or there have been such materials, it has to be put on exhibit so that the court would have taken a view of it. That is not there because of the fact that is there. But admittedly, the concern and the case the person. And if my lord take note of this aspect, as I pointed out, the Procedural 9 has said that on such and such date, on 9/6, he had been to the police station. On being confronted, the concerned IO has said, although he has joined on 14/9, he has said that no, on 9/6, the Procedural had not been to our police station. The Procedural 11 has joined on 14 6, 2016, as per his evidence, my lord. Now, on being asked, he has said that no, PW 9 had not been to our police station.
He might have collected the information from the other officers who are by that present. He must be aware that.
This evidence that I have.
କାରଣ PW9 ର ଏଭିଡେନ୍ସ ଯେତେବେଳେ ଆସିଲା, ଯେତେବେଳେ ଜଣେ ଆଇଓ ଆସେ କୋର୍ଟରେ ବସେ, ସେ ସବୁ ଏଭିଡେନ୍ସ ପଢେ apart from his own case diary, what evidence has been adduced, because he is to be put questions on the other witnesses also. ତ ସେତେବେଳେ ହୁଏତ ଏମିତିଆ ଷ୍ଟେଟମେଣ୍ଟ କିଛି ତା ନଜରକୁ ଆସିଥିବ ଯେ PW9 ଏଭଳି କହିଛି, ତ ହୁଏତ ସେ ଜାଣିଥିବ। ତେଣୁ ଆପଣ ପଚାରିଥାନ୍ତେ ଯେ ଆପଣ ଯଦି 14 ତାରିଖ ଦିନ ଜଏନ କଲେ, ତାହେଲେ 9 ତାରିଖ ଦିନ ସେ ଆକ୍ୟୁଜ୍ଡ ଆପଣଙ୍କ ଥାନାକୁ ଆସିନଥିଲା ବୋଲି କେମିତି କହୁଛନ୍ତି? Again, you have to give ଖାଲି ସବୁ ଜିନିଷକୁ ଆମେ ଇଏ କଲେ ହବନି।
And take note of another aspect also. It is his evidence that he has not seized those requisition or BHFS sent to those persons. To fortify my submission that it was antedated or a planted one, he has also admitted that he has not seized the requisition sent to the police station, the SP as well as the executive magistrate to come to the spot for the particular purpose. And he has also said the BHF
spot visit ତ ହେଲା ଯାଇକିନି 17 ତାରିଖ ଦିନ ନା। ହଁ,
ସେ କହୁଛନ୍ତି ଯେ ମୁଁ 16 ତାରିଖ ଦିନ ପଠେଇଥିଲି SP to I have sent it to SP as well as executive magistrate on 16.
yes,
He has said that I have not seized.
okay.
Thereafter, he has said that it's because it was on BHF basis. I have not made it detailed requisition. Then thereafter, although it has been again it was asked whether you have seized that BHF message or not, it is his answer that no, I have not seized the BHF message. So from this, an adverse inference, my lord, can draw to the extent that, in fact, as I have pointed out, the affair which was there or the information which was available to the police regarding the commission to have committed by some person, not exactly the person who are the petitioner who is the accused person, and this affair which has been subsequently planted, specifying the name or role of the affair.
It is antedated, as you said. That we have noted.
And that apart also, my lord, again to substantiate this plea, the scribe,
like in suppose in Dokaiti cases, also this newspaper clippings help have been taken, that ଦେଖନ୍ତୁ ସେ ଅମକ ତାରିଖରେ ଯୋଉଟା ପବ୍ଲିଶ ହେଇଥିଲା, ଏମିତି ଗୋଟେ ପେପର, ତମେ କୋଉ ପେପର ପଢ, ସମାଜ ପେପର ପଢ କି ନାହିଁ, ଏ ସମାଜରେ ଏମିତି ବାହାରିଥିଲା, ସେ ହଣ୍ଟା ମାରିଦବ ସେ ତାକୁ, ଜାଣିନଥିବ ତାର ଇମ୍ପୋର୍ଟ କଣ ହବ ବୋଲି. So ordinarily it is done in that way, and that would show that sometimes their faces are open, and obviously
always,
they are
so the
yes,
photographers always prefer to take photographs with the face,
that is
open face.
That is done, but now very with all sincerity these things have been, they are kept on Baparda. All right, please proceed.
The scribe of the affair,
yes,
also not been examined, at least to support my contention to that, in fact, my lord, whether the person, the affair was on such and such date or any other things, my lord. And prosecution has deliberately preferred not to examine this type of the affair, even though charge sheeted, my lord. And by the process, my humble submission, as I have pointed out, that the affair is a planted and undated one, is substantiated that had there been an examination of the scribe of the affair, at least the prosecution, the defense would have got an opportunity to examine that aspect, and this aspect would have been more highlighted than that of the present stage, where I am not, even though I am harping upon all these things, but I am totally not in a position to give a clear picture. And the prosecution has deliberately suppressed this scribe of the affair. By the process, the defense has been prejudiced.
Okay, we are just coming within 2 minutes.
Next. So as I have prayed, that the particular affair is a planted one, and because of the fact that the IO has also not examined the previous IIC who was there at the relevant time and has also not been taken care of this aspect, that it's been alleged that there was a published note to wide publicity of these things in the newspaper, and these things has not been taken care of during investigation, and deliberately it has been done by the IIC for the investigation for the particular purpose, for which at least an adverse inference can be drawn on the prosecution to substantiate my right of the claim that there was an affair and it has been deliberately suppressed and the new affair has been inserted, wherein because of the fact some glaring infirmities which is appearing in the spot visit report has not been taken care of. And besides this, my lord, I will pray, my lord, because my friends have already pointed out all sorts of things. One thing, my lord, may take note of Pidol 1, the evidence which has been presented and claiming to be the eyewitness, and the prosecution has deliberately left one angle wherein the presence of the house, that means the cow shed, wherein the first part means because of the fact that the prosecution has failed to prove this subsequent aspect, because as per the prosecution case, there are two-fold of occurrence place of occurrence spot, but in fact, prosecution has at least proved at present because of from the mouth of Pidol 1 that there was in fact one spot of occurrence. There is none other than cow shed. So Pidol 2 being the alleged owner of the particular cow shed, it is his evidence there was no cow shed, because it is in his evidence he has specifically said there's no cow shed, and the prosecution has also not substantiated to that in fact by examining any revenue authority in fact whether there was any cow shed or not. This aspect has been somewhat left out.
No, this in the spot visit note, sorry, spot map, that is at page he was pointing out on that day 341. Just a minute. No, that is spot visit rope. That spot map we are referring
spot map, 345 and 346.
345 and 346. Particularly this 346 we are referring. It is shown that one cow shed is there, and what is the distance of that cow shed from that main area of that cremation area? It is stated that 250 meters is there. So this is being shown, and of course in this spot map it is not mentioned that whose cow shed it is there. Though PW5 has stated that I have no such cow shed, but it is the prosecution case that it is the cow shed of PW2, right? So,
and one more thing I want to add in the particular spot map, I have a glance to this particular page 346. Although they have said regarding this cow shed, this cremation ground, this church, everything is there. And admittedly, it is the case of the prosecution that she had been to a particular place of nearby to it, wherein she was watching for the purpose of giving some maize or for watching of the TV, the Pidol 1 melon. That particular house has not been shown. And nowhere in the spot map, you found a single house of any resident of the nearby locality. At least to take note of the presence of the other houses nearby to it, because it is a specific case that although all such time for about 1 hour or 2 hours where the assault was there, but not a single person of the locality had been to the particular place. That is evident from the evidence of Pidol 1. Because when such assault was there, definitely there will be hue and cry. It was not for a single assault was here. It was a continuous one. It was a continuous one for a particular period, and not a single person of the locality had been to the particular place. And as because of the fact that prosecution has deliberately suppressed in the spot map regarding the presence of the houses of the nearby locality, or at least it was a village, it is well expected the village of that when the cow shed is there, supported by a house of the person to a nearby locality, and the other persons of houses must be there in the particular things, but not a single person's the residence has been shown in the spot map.
No, your submission is that the uh, people of the locality would have gone to that place if such an incident has
there and if such
taken place, and any information would have come to their knowledge that has happened, they would have definitely gone to the this cow sheds, also to the cremation ground.
Immediate not in the propeller, because as per the prosecution, they have proved to this extent. Although in the judgment, the Planet Court has taken note of that there was 2 spot of occurrence. I don't know where from is got it, because the entire evidence based on the one occurrence, and the other occurrence is the story as has been advanced and told to the Procedural one informant by the others. But the prosecution has failed to, and in particular, IO has also admitted in his evidence that there was 1 spot of occurrence. That is evidence. I will place all later, my lord. But one thing I am clear, that had there been any cow shed, because as per the prosecution case, the evidence of Procedural 2, there was no cow shed. And let us go to the host view, and there was a cow shed. And if there was a cow shed, and the persons have been dragged to the particular cow shed, none of the persons in the locality had been to the particular place. And definitely it was the occurrence as per the prosecution case, if taken note of, it was happened for about 1 hour or like that, because assault was there. They regained they became unconscious. They again gained consciousness, and again they were assaulted. Also things were, and they've been dragged from the particular place to an unknown place. So all these things could have taken note of this by the process. Some hue and cry must be there, and by the process the neighboring persons. But it is well expected on the evening hour, and it was a village in the evening hour. But this sound must have attract the mind of the other persons, at least to be there, and by the process, none of the persons of the locality has also been examined. It is well expected in the village that the houses are very near to one another for various purpose, and by the process, neither the spot map shown any existence of any houses in the nearby locality at the nearby area of the spot, nor also the prosecution has examined any
No,
person.
but PW1 has stated that houses are there nearby.
Where is in the spot,
No, it is not shown in that spot map.
And even the church, the church is also nearby vicinity, it is 100 meters. None of the person of the church has been examined, at least whether there was any cremation on the relevant day or not. Second part of occurrence, of course, the second part of the occurrence. Then not of the person of the church were examined, and church is always to be with a particular person.
No, it was that occurrence took place in the evening hours, and that cremation or burial also took place in that night itself.
It is not no, I do consider that as per the
ଯଦି
evidence,
ତାଙ୍କର PW1 ର evidence କୁ ଦେଖାଯିବ, ତାହେଲେ ସେଇ ଯାହା ବି ଯଦି ହେଇଥିବ ସେଇ ରାତିରେ ହିଁ ସବୁ ଜିନିଷ ହେଇଯାଇଛି, କାରଣ ତାପରେ ତାକୁ ଯୋଉ ଗାଧେଇବାକୁ କହିଛନ୍ତି,
gold chain was returned. That was there.
ତ ସେଗୁଡା ସବୁ ରାତିରେ ହେଇଛି.
Even if that is there, my humble submission, because of the fact that the church was in a nearby vicinity, and when all these persons were dragged out from the particular cow shed to the nearby burial or the cremation ground, which is a distance of 250, and whether any existence of a house in between or not, that part is prosecution is silent to that effect. So by the process, my lord, because of the fact that none of the person has been examined, and by the process, the defense has also prejudice to give a clear picture whether in fact there was an occurrence or not. And even if that is there, that the particular cow shed, my lord, as because of the cow shed, the petticoat, blood-stained petticoat allegedly was seized, my lord. And nowhere it has been, although it has been seized by the prosecution, nowhere it is the case of the, nowhere in the statement, either in the FIR or in the 164, nor also in the before the court, the PW1 said about anything that by the process of assault, any petticoat relates to his or mother or sister.
No, that is not there. One says that petticoat was there, but whose petticoat it was, and that is not there.
That part is not there. And that part, the important aspect is that when the storm,
any earth was collected from that place by the IO, Mr. Das, any sample earth or blood from that cow said nothing.
Only Saya was seen. And that spot map by the IO, my lord.
Is there any evidence from the side of defense with regard to houses situated around within the vicinity of the cow shed?
PW1
No, defense evidence. Evidence to show.
Not bought in the defense.
Defense evidence nil ଅଛି.
Jura spot map visited the Kotle, the capital cow shed, madam. That I was mentioned in the spot map, 43 page, my lord.
कितने पेज?
343. Spot map by the IO method. DSFL Cora board. He has mentioned in that one green colored saya suspected to contain blood stain was detected inside the cattle shed of Girijan suburb. Pidol 2. যেটা কাহারা বলি যেটা dispute করলে that he has mentioned that from the Girijan suburb also he has seized melon.
No, but what happened to that saya?
Saya was
It has been seized, my lord.
Report file, nothing. This is the spot visit report.
And the report of the FSL is at page 158.
Saya যাইছি সেটিকে
exhibit C.
Again,
Blood stain could not be detected.
अच्छा कितना नंबर पे?
Page is 155.
155.
This is the ground you asked them to
সায়াটা कितने मार्क ହେଇଛି?
এটা ହେଲା exhibit my lord
C.
Description of exhibit search at serial number 5.
Saya with blood stain. C my lord.
C ହେଲେ
Result of examination of the blood stain
result of
could not be detected.
examination C টাକୁ পেয়েছি হয়
In between ଅଛି.
C ଅଛି.
B1 C F 1.
Substance could not be detected.
Also not the case of the prosecution that this saya belongs to any the person. So it has no relevancy of regarding seizure or subsequent sending it. And the stomp was also not seized, and it is also a specific case of the prosecution that the 3 persons who have been allegedly murdered, my lord, including the informant, were tied up by means of rope. Rope has also not been seized. And if there was some assault, and by the process they became senseless, and it is also the specific case that 7 except the mother and sister, the other father was also having some blood coming out from his mouth and other parts, my lord. So definitely, my lord, the presence of blood either in the stomp or in the that particular cow shed must be there. And besides this, also pesticides has been used by the it has been pierced into several parts of the body, and by the process of presence of some pesticides drop at least must be there in the particular places. And when thing has been the injection has been pierced on the face and other part of the body, and definitely some this blood, it is well expected it should come up. But as also presence of blood is not there. And as I have placed people in the report that because of by the process severe pain must have been there, because had it been occurred in such a case, that there is severe pain, and severe pain always comes with a sound for cry of
Obviously,
help.
shouted,
and Malad may take note of the evidence of the Pedal 1. Nowhere she has said that by the process any person has raised any halla, any cry, even cry, at least to beg excuse that forgive us or don't commit suicides, or trying at least to take the knowledge of the other persons in the nearby vicinity that please come and help us. That was also not there. So by the process, as if they were the plastic or rubber like persons, and with all assault was there, but they have not shouted anything well. It is very uncommon.
In other words, it can be in this way that had the occurrence taken place in that manner, definitely that girl, that sister of the PW1 would have shouted, which would have drawn the attention of others.
Not only PW1, but also his father and mother.
Mother. No, mother had not.
Even if let us say take up mother has not been assaulted, solid, but in
shouted
front of
out of pain and all these things. to help to rescue them.
And in front of the one person of the family, other persons were assaulted. That is the case of the prosecution. Then definitely the other person is very common that he should try or all best to get the attraction of the other persons and to raise halla so that they will come up and to at least assist. And it's a village in the evening hour. And it is well expected that all the persons of the nearby vicinity who have the houses, although that is silent, that is expected in the spot visit report, but they should come up and to take assistance, help, whatever possibility they can. They may not help the persons to assault because of fear or anything else, but at least they can reach this particular place. That is also not there.
Yes.
And that part, well, although it, admittedly the particular night of occurrence was a rainy day night, and this is the specific evidence of the prosecution. There was no electricity on the available in the cow shed. The visibility definitely is much less in the rainy day night, my lord. And because of the fact that there was no visibility in fact in the cow shed, the allegation which has been come out from the mouth of the evidence in shape of say by PW1 Mallard that this person has said that is because of the judgment of the honorable court language of some persons. Because although she has said that by the ray of light coming out from the house of
right in para 8
to specifically mark the overtake
individual
committed.
road, exactly, individual established by prosecution. And whether
any question has been put to the IO that have you gone to the house where it reaches the cow shed or not? Any such a question has been put.
No.
And this is all this.
For that because of the laches or lacuna of the investigating officer in favor of the accused person. I don't dispute to that matter. But my humble submission, since it's a case, the death penalty is there.
Unless until it is confronted, laches has taken.
Sir, at present, if I would take note of this aspect, that in fact this aspect has not been taken care of, and admittedly defenses were not examined to that effect. But the honorable court took note of this aspect that by
light ପଡୁଥିଲା ଏଟା ମିଛ କଥା ବୁବୁନାର ଇଲେକ୍ଟ୍ରିସିଟି ନାହିଁ ବାବୁନା ଘରୁ ଲାଇଟ୍ ସେଠିକି ପଡି ପାରିବ ନାହିଁ ବା ଏଇ ଟାଇପ ର କିଛି ପଚାରିଛନ୍ତି 1 ନମ୍ବର ସାକ୍ଷୀକୁ ଆପଣ
ସବୁ ଛାଡି ଦେଇଛନ୍ତି
କେମିତି ଆପଣ ଏକ୍ସପେକ୍ଟ କରୁଛନ୍ତି ଆପଣ ତାଙ୍କୁ ପ୍ରଶ୍ନ ଯୋଉ ସାକ୍ଷୀଟା ଆପଣଙ୍କର କହିଲା ଯେ ମୁଁ ଏଇ ସୋର୍ସ ଅଫ ଲାଇଟ୍ ରୁ ଦେଖିଛି ତାକୁ ପ୍ରଶ୍ନ କରିବେନି ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବେନି ଯଦି ପ୍ରଶ୍ନ ପଚାରିକିନି ଇଏରେ ହାଉ କ୍ୟାନ୍ ୟୁ ସେ ଦ୍ୟାଟ୍ IO ଏଇଆ କରିଥାନ୍ତା ଏଇଆ କରିଥାନ୍ତା ଏଇ ସବୁ ଜିନିଷ
I do consider that because of these latches I cannot get the benefit, but my humble submission
ଆପଣଙ୍କର ଚ୍ୟାଲେଞ୍ଜ ନାହିଁ ମାନେ you are indirectly you are admitting that there is that it is possible that on the light source which is telling that it would have so
I have only to this extent I have there is a electricity connection available in Nagal, but no street light are available. I cannot say if it was a full moonlight day or new moonlight, but from the electric light of Buna's house, the spot was quite visible. There was about 25 houses in our villages, and church is situated exactly in the middle of the portion. The spot we would call, and about 7 to 8 houses intervened between the church and our houses. And on Ananta's house and our house are situated adjacent to each other. Being
no, where is the house of PW1 as per the spot map?
No, I think it
has not been shown. Only the cow shed and the cremation ground.
And all take note of this.
And the church.
So, these 25 houses, as has been brought out from the cross-examination, that is also not available.
PW2 ର cow shed ମାନେ ତା ଘରଟା ବି ସେଇ ପାଖାପାଖି
ନିଶ୍ଚିତ ଆଜ୍ଞା
ତ ଯଦି ସେଇଆ ହେଇଥାଏ
no the location of the house of PW1 is not indicated in the spot
no
PW1 nahi PW2 nahi appellant jo from the
spot map
ray of
means
light
the cow shed and the cremation ground that's all.
And it is the evidence that there are 25
But the
houses.
state evidence has not been challenged, sir. P1 with regard to location of the house of Bhuvana.
କ୍ରିମେସନ ଗ୍ରାଉଣ୍ଡ କୁ ଆସିବା ବାଟରେ 25ଟା ଘର ପଡିବ ବୋଲି ସେ କହୁଛି ନା
ଆଚ୍ଛା,
କେତେଟା ଘର?
25ଟା ଘର ଏବଂ ସେ ଭିତରେ ଚର୍ଚ୍ଚ ବି ଆସୁଛି।
କାଉସେଡ ରୁ କ୍ରିମେସନ ଗ୍ରାଉଣ୍ଡ ରେ କଣ ଘର ଅଛି?
କାଉସେଡ କଥା ନାହିଁ, ସେ କହିଲା
ହାଉସ ଅଫ
I am again reading, I cannot see ଗଲା but
to the କାଉସେଡ
କୋଉଟା ପଢୁଛନ୍ତି ଟିକେ
ଆଜ୍ଞା page 106
just a minute 106 yes
para 8 my lord, first second third line my lord. There are about 25 houses in our village and church, which is the spot of occurrence in your my lord, has been shown. That is church is situated exactly in the middle portion. So if that will be there, then the graveyard and everything is always bind my lord on the close vicinity to the houses. They situated exactly in the middle portion. About 7 to 8 houses intervened between the church and our house. Ananta's house and our house are situated adjacent to each other, being intervened by a narrow lane.
The said location is not shown in the spot map, sir. So,
but I cannot say if there is a house in the northern side.
କାରଣ ଯଦି ମିଷ୍ଟର ଚାନ୍ଦ ଯଦି ହାଉସ ଗୁଡାକ ମନେ କରନ୍ତୁ ସ୍କାଟର୍ଡ ହେଇକି କୋଉଠି କଣ ଥିବ, ତେଣୁ ଏସବୁ ଆସମ୍ପସନ ରେ ଇଏ ନା, ଯଦି ହଁ ପାଖାପାଖି ଆପଣ ସେମିତି କିଛି ଏଭିଡେନ୍ସ ଆଣିଥାନ୍ତେ, ଆୟୁକୁ ମଧ୍ୟ ପଚାରିଥାନ୍ତେ ଯେ ଘର ଗୁଡାକ ପାଖାପାଖି ଥିଲା ନା ନାହିଁ ସେ ଇଏର, ସେ କହିଥାନ୍ତା ହଁ ତାହେଲେ ସ୍ପଟ ମ୍ୟାପ ରେ କଣ ପାଇଁ ଆପଣ ଦେଖେଇଲେନି, ବହୁତ ଜିନିଷ ପଚରା ଯାଇ ପାରିଥାନ୍ତା ଆୟୁ।
The house of P1 may be located at some distance from the church, which is therefore not shown in the spot map. And the spot map is only confined to the cowshed and cremation ground.
Cowshed, cremation ground, church. That's all.
Since it is in close vicinity. So therefore it has been shown, that's all.
And it is evidence that the church is situated in the middle and surrounded by other houses. And para 10, the straw roof that cowshed was at the Hans, my lord. And this spot aspect has also been not taken care of. Is there? But admit
ଆପଣଙ୍କର ଯଦି ଆଣିପାରିଥାନ୍ତେ ଏବଂ ଆପଣ ଯୋଉ ସାକ୍ଷୀ ଗୁଡାକ ଆପଣଙ୍କର ହୋଷ୍ଟାଇଲ ହେଲେ ତାଙ୍କଠୁ ବି ବହୁତ କିଛି କଥା ଆପଣ ବାହାର କରିପାରିଥାନ୍ତେ, ତାକୁ ବି କଲେନି ଆପଣ। କାହିଁକି ନା ଅନ୍ୟ ଇଏ ଦେଖନ୍ତୁ, he can argue also in the other way. ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ଯେ ଏମାନେ ଯଦି ଅନ୍ୟମାନଙ୍କ ଆଟେନସନ ଡ୍ର ହେଇଥାନ୍ତା, ଅନ୍ୟମାନେ ଆସିଥାନ୍ତେ ଘଟଣା ଜାଗାକୁ ତାଙ୍କୁ ରେସ୍କ୍ୟୁ କରିବାକୁ ବା ଯାହା କରିବାକୁ, it may be so that since the villagers are aware that such a thing is going on, maybe out of fear that ଆମେ ଗଲେ ହୁଏତ ଅସୁବିଧା ହେଇପାରେ, ଯେ ଏମାନଙ୍କୁ ନେଇକି ନେଇଛନ୍ତି ତାଙ୍କୁ ଏଇ ଟାଇପ ର କରୁଛନ୍ତି, ତେଣୁ they might have apprehended something, might not have decided or think it proper to go to that place. ହେଇପାରେ ଛୋଟିଆ ଗାଁଟା 25ଟା ଘର ସ୍କାଟର୍ଡ ହେଇକି ଥିବ, ଯାହା ଘର ବି ଯେ ପାଖରେ ଥିବ, ଯଦି ଏଭଳିଆ ଘଟଣା ତାକୁ ଆସିଥିବ ନଲେଜ କିଏ ନା ଏମିତି ବାଡିଆ ପିଟା କରୁଛନ୍ତି, ଲେଟ୍ ଅସ୍ ସେ ସେ ନିଜ ଫ୍ୟାମିଲି ବା ନିଜ ଇଏ ରିସ୍କ କରିକି ନିଜର ଲାଇଫ ରିସ୍କ ହୁଏତ ସମସ୍ତେ ଯେ ଚାଲିଯିବେ ଆଗ ଘର ହେଇକିନି ଗୋଟେ ଘଟଣାରେ, ଯେତେବେଳେ ଘଟଣାଟା ହୁଏ ବିଚ୍ ଇଏରେ ମଧ୍ୟ ଲୋକ କବାଟ ଝରକା ବନ୍ଦ କରିଦିଅନ୍ତି ଯେ ଆମେ ଗଲେ ଆମେ ଅନନେସେସରଲି ତା ଦେହରେ ଇଏ କରିବା। ଇଟ୍ସ ଡିପେଣ୍ଡସ୍ ଅପନ୍ ଇଏ କି କିଏ ଆସିଯିବ ହେଲ୍ପ କରିବାକୁ, କିଏ କୋଉ ଲୋକାଲିଟିରେ କଣ ରିଆକ୍ସନ ହବ, ଇଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ତେଣୁ
my humble submission, since it is admitted by the IO that prior to 4 years, 7-8 years back, on 2 occasions, the villagers have manhandled the persons, villagers, not the persons, villagers have manhandled the deceased for such alleged act of witchcraft. That's why the possibility of other persons' involvement must be there. Because as per the prosecution, even if that is there, that these persons have first initial part is there against those persons, and when they have been taken to a other aspect, they have been from the first particular cowshed, they have been brought out. Thereafter, the villagers might have also done things, and that's why the name of villagers is found place in the spot report. That's why as I have pointed out that there may be a tampering or manipulation or
ଯଦି prosecution case ଟା ଏଇଆ ହୁଏ ଯେ କିଛି ଲୋକଙ୍କ ଦେହ ଖରାପ ହେଇଛି, କିଛି ଲୋକ ମରିଛନ୍ତି, ଯୋଉଥିରେ ସସ୍ପେକ୍ଟ କରାଯାଉଛି ଡିସିଜ ର ଇନଭଲଭମେଣ୍ଟ, ଲେଟ୍ ଅସ୍ ସେ ତାର ସେ ଯୋଉ ମେଲ୍ ମେମ୍ବର,
ଆଜ୍ଞା
ତାହେଲେ possibility that not only the accused persons but some other villagers might have grievance against the deceased, at least that male man
ହଁ
that who has died. ତେଣୁ but here these are all that possibility, but
Right.
here unless you overcome the evidence of PW1 who has specifically implicated, then
Rather, it would show that because of the earlier incident, the disease was targeted.
No, my humble show in such a case that in the year 2008
Uh,
and 2011 that is there. That is admitted by the villagers. So my humble submission, if that is there, so at the relevant time, it is admitted that there was no case. It's all right. It is possible no case is there. But subsequently, at least the persons who have assisted the persons, like the two persons have threatened, one person have called her from the politician, from the neighboring house, and took her to the particular place. Those three persons were also not charged sheeted. And if I'm going to take note of, while cross-examining in a particular witness, the concerned court has also taken note of this aspect, perhaps with the intention to add him as an accused under 319. That's why the court has asked about the address, so name, address of the person who has allegedly taken part of these things, but subsequently left out. That is there. Evidence is there that while PW 7 while examining, the court has also taken note of this aspect, and
IO has been asked as to why three of the persons are let off. No.
Nothing is there. No? That's why I'm not in a position to give a. It has been started. The defense has tried to get inside, but subsequently.
Is it the legal that defense counsel that or
because the fact that scheduled tribe persons are there.
No, এটা court engage କରିଥିଲେ counsel କୁ ନା ସେମାନେ ନିଜେ engage କରିଥିଲେ?
Vishnu Prasad Panda.
Advocate is there.
Defense.
Defense
counsel.
Defense
legal aid.
legal aid ମୁଁ ସେୟା ପଚାରୁଥିଲି।
First ନା second ରେ ଥିଲେ। second ରେ private advocate ଥିଲେ।
ଆଚ୍ଛା first ରେ ଇଏ କରିଥିଲେ।
ରାୟଗଡ଼ାରେ ବିଷ୍ଣୁ ପ୍ରସାଦ ପଣ୍ଡା।
ଜଜମେଣ୍ଟ ରେ କାହା ନାଁ ଆସିଛି ମାନେ
ସେକେଣ୍ଡ ଟା ଆଜ୍ଞା
ଫାଷ୍ଟ ଜଜମେଣ୍ଟ ରେ କାହା ନାଁ ଆସିଛି ସେକେଣ୍ଡ ରେ ଫାଷ୍ଟ ଜଜମେଣ୍ଟ ର ପେଜ ନମ୍ବର କେତେ ଅଛି କି ପେପର ବୁକ୍ ରେ ଅଛି ସେ ଜଜମେଣ୍ଟ ନାହିଁ
ଫାଷ୍ଟ ପେଜ ହଉଛି 141
ଫାଷ୍ଟ ଜଜମେଣ୍ଟ ଟା
ଫାଷ୍ଟ ଆଜ୍ଞା 141 ପେଜ
ଦେଖିଦବା ଟିକେ
ପ୍ରିଭିୟସ୍ ପେପର ବୁକ୍
ଯୋଉଟା ଆମର ଏଇ କୋର୍ଟ ରେ ସେଟାସାଇଡ ହେଇକିନି ଗଲା ଯୋଉଟା ସେ ଜଜମେଣ୍ଟ
ପ୍ରିଭିୟସ୍ ରହୁଛି
ଫାଷ୍ଟ ଜଜମେଣ୍ଟ ହେଲା ମାଇ ଲର୍ଡ on 13/4/2018.
Now, where is that in the paper book, sir?
ଫାଷ୍ଟ ଗୋଟେ ପେପର ବୁକ୍ ହେଇଥିଲା
ସେଇଆ
ସେଥିରେ ପେଜ 140 ଥିଲା
13/4/18
The advocate was one Umacharana Pattanaik. Associate advocate.
But the entire case has been summed up by the subsequent counsel, defense counsel.
And subsequently, that another final judgment was before my lord. That is on
Which one? This one?
21/10/2021.
that is name is mentioned Vishnu Prasad Panda, associate advocate Rayagada. She obviously କହିଥାନ୍ତା ଯେ ମତେ ଯେତେବେଳେ ମୋ ଇନଭେଷ୍ଟିଗେସନ ଚାଲିଥିଲା ମୋ ପାଖରେ କୌଣସି ଇନଫର୍ମେସନ ନଥିଲା ଯେ କୌଣସି ଲୋକ କଲରାରେ ମରିଛନ୍ତି ଏଇଆ ହିଁ ସେ ଆନ୍ସର ଦେଇଥା ତେଣୁ ତାକୁ ପଚାରି ନାହାନ୍ତି ଆପଣ କିଛି ଆଉ ଏ କଲରା କେସ୍ ଟା ଟୋଟାଲି ନ୍ୟୁ କେସ୍ ମାନେ which was not there in 161. Your witnesses, your means prosecution. So
and And the version of the Procedural 1, my lord, as my lord has found in the FIR 164 vis-a-vis court, is totally a developed one.
No,
And
160, you are right. 164 is a developed version. We have also marked it. Many things have been stated.
All things, my lord, with all
we
respect.
asked a question and he has tried to explain it away that after 3 days of the lodging of the FIR, when he was in the police under police control. Police control means she was feeling safe, and that fear psychosis which was there might have dispersed, and therefore he might have recapitulated many things what has happened during that period. So as such, he has given that statement in 164 like that. So in that scenario, it cannot be said that something which has been added in the 164 CRPC statement makes the this witness is a unworthy witness or that unreliable witness. He is trying to explain it, Mr.
And so far,
Basis.
the delay of lodging FIR, as has been settled, that 1 day, 2 day delays will also is a fatal for the prosecution, and if not properly explained. My humble submission is a case where 3 persons of the family who are the main source of livelihood of, or the persons who are in fact maintaining the Procedural 1, they have been killed. And it is also not the prosecution case that she was under a custody or she was prevented or she was at any point of time, although it has been said that pure psychosis was in our mind, but that whether the pure psychosis override the entire things or which she has feel it not proper to go and to lodge the affair, because the fact that the only source of our livelihood is the 3 persons, because of their presence, she was in a position to be living properly. So when all these things have been eliminated, all those 3 persons are allegedly assaulted and subsequently murdered, as has been told by. So whether the girl will stay in the house for 5 days, and admittedly on cross-examination she has said that before she is lodged the affair, she has not disclosed to anybody.
No, Mr. Das pointed out that 3 are left out. Those are very young kids. He's deposed by. So the silence of PW1, even after this,
she has informed about or burial, is that they have been killed no more. So why she has preferred to remain as such, not informing any person, not any information? Let us accept that she has not informed the police. All right, my lord. But it is well expected that it is a common person, common nature. They should at least tell or disclose it to any person, at least in whose house she was staying. It is her evidence that she stayed in the house of an appellant for about night in the next night, or thereafter also for about 5-6 days in a particular house of the person. There also she has not disclosed to anybody. So this conduct,
that man even has not stated that this lady was staying in his house.
Yes.
That is there. We have verified also.
So if
the 161 statement yesterday that man has
The
not.
incident was well within the knowledge of the said witness, even though he has turned hostile, because he was very much present, physically present in the meeting. So what to disclose?
No, my humble submission, because it is the evidence of this girl that there was a meeting. But the prosecution has not examined any person, except the evidence of this girl. No other persons were there, or no other person has been examined to the defect. And if I take note of that particular evidence of 164, 164 doesn't say that she was present. If the exact verbatim, my lord, I am pressing the exact verbatim like this, my lord.
Page is 98. No, 95 it starts. But extrajudicial confession is paragraph number 9, page 98.
I am flashing, my lord.
Just a minute.
ପାରା 9 ଆର ଦିନ ସକାଳୁ ପାହାଡ଼ ଉପରେ ପିନ୍ଧିବାକୁ ଆର ଦିନ ସକାଳୁ ପାହାଡ଼ ଉପରେ ମିଟିଂ ବସିବାକୁ କହିବାରୁ ମେମ୍ବର ସମିତି ସଭ୍ୟ ଆମ ଗାଁ ଲୋକମାନେ ଆସିଲେ ଓ ଆସିକି ସେ 10 ଜଣଙ୍କୁ କାହିଁକି ମାରିଲ ବୋଲି ପଚାରିବାରୁ ସେମାନେ କହିଲେ ତାଙ୍କ ପାଇଁ ଆମକୁ ଜ୍ୱର ହେଉଥିଲା ଓ ତାଙ୍କୁ ସ୍ୱପ୍ନ ଦେଖି ଆମମାନଙ୍କ ଦେହ ଭଲ ହେଉନଥିଲା, ତେଣୁ କରି ତାଙ୍କୁ ମାରିଦେଲୁ। ସେମାନଙ୍କୁ କହିଲେ ଆମେ ମାରିଛୁ ବୋଲି ତା ଝିଅ କାହାରିକୁ କହିବ ନାହିଁ। If I take note of this, ତା ଝିଅ means the PW1 is not there, because ସେ ଝିଅ ବା ଏ ଝିଅ କହିଥାନ୍ତେ, ତା ଝିଅ means she was not there. That is my humble submission. Again I am pressing, ତାଙ୍କୁ ସ୍ୱପ୍ନ ଦେଖି ଆମକୁ ଦେହ ଭଲ ହେଉଥିଲା, ତେଣୁ କରି ତାଙ୍କୁ ମାରିଦେଲୁ। ସେମାନଙ୍କୁ କହିଲେ ଆମେ ମାରିଛୁ ବୋଲି ତା ଝିଅ କାହାରିକୁ କହିବ ନାହିଁ କି ସାକ୍ଷୀ ଦେବ ନାହିଁ।
Just read
thereafter. Yes, I do concede. ସେଠାରୁ ସମସ୍ତେ ନିଜ ନିଜ ଘରକୁ ଫେରି ଆସିଲୁ। So this ତା ଝିଅ and ଫେରି ଆସିଲୁ, if I take note of ଆସିଲୁ means she was there. If I take note of this ତା ଝିଅ,
ନାଇଁ ଆସିଲୁ କେବଳ କହୁନି, ଅଧା ରାସ୍ତାରେ ମତେ ଧମକେଇବାରୁ ମୁଁ 4-5 ଜିନିଷ ଏଗୁଡାକ ଏକାଠି ରେଡ୍ କରିବେ ନା ଗୋଟେ ଆଇସୋଲେଟେଡ
my humble submission, because it is recorded in the exact verbatim of the counsel, if PW1, if that is so, and she has also not said that I had been to the particular place. Yes, of course, it was there that the ପୂର୍ବରୁ କହିଥିଲେ ତାକୁ ଯିବା ପାଇଁ ପଡିବ। Nowhere she has said that I had been to the meeting.
ଅଧା ରାସ୍ତାରୁ ମତେ ଧମକେଇବାରୁ ମୁଁ 4-5 ଦିନ ଧରି କାହାରିକୁ ଏକଥା ନ କହି ଲୁଚିକି ରହିଲି। ଅଧା ରାସ୍ତା been to the spot, sir.
And none of the person and this particular my humble submission,
9 paragraph ର ପୂର୍ବ ସେଣ୍ଟେନ୍ସ ଟା ମୋତେ କହିଲେ ଆମେ କାଲିକି ମିଟିଂ ବସିବା କହି ଶୋଇଗଲୁ ହେଲା। ତାପରେ ଏଇ ଜିନିଷ ଗୁଡାକ ଆସୁଛି ଏବଂ ଏଣ୍ଟାୟାର ଇଏଟାକୁ ଯଦି ରିଡ୍ କରିବେ, ଏଇ ଯୋଉ ଦିଟା ପର୍ଟିକୁଲାରଲି ଆପଣ କହୁଛନ୍ତି ନିଜ ନିଜ ଘରକୁ ଫେରି ଆସିଲୁ ଏବଂ ମୋତେ ବାଟରେ ଧମକାଇଲେ, ଏଥିରୁ ଜଣା ପଡୁଛି ଯେ ମିଟିଂ ରେ ଆର ଉପସ୍ଥିତି ବିଷୟରେ ସେ କହୁଛି, ତେଣୁ ତା ସାମ୍ନାରେ ଏଇ ଘଟଣା ହେଇଛି।
my humble submission, if that is there, this was available to the prosecution. None of the person of this particular person
that is there. Other persons were stated, କାରଣ PW7 ମେମ୍ବର ସିଏ ହୋଷ୍ଟାଇଲ ହେଇଗଲା, ସମିତି ସଭ୍ୟ ଏକ୍ସାମିନ ହେଇନି ବା ଗାଁର ଯୋଉ ଅନ୍ୟ ଲୋକମାନେ ନେଇକିନି ମାନେ ଥିଲେ ସେମାନେ କେହି ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି। that you are right.
ସେଠି ମଧ୍ୟ ସେ କହିନି ଯେ these things has happened or all these things. In the meeting also she has not, even if let us go to she was there, and in the meeting place also she has not disclosed. In the meeting place also she has not disclosed about all such things.
About what she has seen on the previous day. ସେ ବିଷୟରେ ତ କିଛି ପଚରା ହେଇନି। ସେ ତ ସେ ମିଟିଂ ଟା ହେଇଥିଲା କେବଳ ତାଙ୍କର ଦୋଷ ସ୍ୱୀକାର କରିବେ, ତାଙ୍କୁ ପଚାରିବେ, ସେଇଥିପାଇଁ କରାହେଇଥିଲା। କାଲିକି ମିଟିଂ ବସିବା, ସେମାନେ ତାପରେ ମିଟିଂ ରେ ଇୟା କହିଲେ ଯଦି କିଛି ମିଟିଂ ହେଇଥାଏ ବୋଲି।
10 ତାରିଖ ମିଟିଂ ଟା ମଧ୍ୟ suspicious.
Of course this part is not there in the FIR and in that 161 statement that is there. Right.
So from 9 to 16 where she was, if I take note of that she was not in the house of the person whom she was claiming to be there, then where she was, and whether this particular period of 7 days is sufficient on her part, if she was not under the control of the accused persons, whether this pure psychosis can run to this particular 7 days, so that after 7 days she has lost the affair. And if we'll come
after coming to know that they have been the bodies have been exhumed and cremated.
Yeah. So this 7 days is a crucial period. And in between, because from the very day it was in her mind that her parents and sisters are no more, elder sister was no more. So if that was there, why she has kept mom for these 7 days? And this pure psychosis starts and ends, at least my lord I can say, it was there in the night. Yes, all right, in the night she was under threat, and threat was given by whom? The persons who have not been charged yet, because those persons who have threatened and guarded, because in the specific case one Ananta and another person, they were guarded, one Prabanta or another person Dasanta, they were guarded, they were not the charged person, and they are not the person or the accused person who have threatened. So like in the night threat was there, in the next day morning there when meeting was there, it's all right, in between that was there, threat was there, but thereafter threat and this pure psychosis comes to an end because she was not under the control of, had it been a case or had there been an allegation that she was confined by the appellant, then matter would be something different.
confined or anybody was keeping eye on her about her movement.
But it was there in the
That
night.
evidence is not.
My humble source, it was, let us accept that it was in the night. She was, as stated by her, the two persons were guiding, who are not the charged person. Two persons were guiding her and threatening that don't disclose, and if you will disclose all these things. In the morning also, in the meeting, although that is not the specific case, who is the person who have given this threatening? Whether those two persons who are guiding or who are not charged witness or the appellants. So like to this extent, we can presume that yes, in fact, this fearness was there, which has prevented her not to go and lodge the affair. And but subsequently, my lord, when her existence for this 5 to 7 days is a mystery. Where she was, if I would not believe that aspect, but where this was or in the house of, also it is a clear version, exaggerated version. Then where she was. So under such circumstances, if her existence or her presence anywhere else, not under the control of the appellant, was there, it will be believed. Then why she has kept mum for these 6 to 7 days, my lord? And the place of the her residing to the police station is only 3 kilometers. And for a common villagers or a rustic persons like the girl, it is 4 to 5 minutes to reach the destination. And her silence to suppress all such things for about 7 days. And my humble solution, had there been a previous disclose, at least the story of burial before body was cremated would have been open up. And as my lord knows, each and every person, as at least the person like a blood related person, will never spare the assailant. That is the judgment made law. And if the pure psychosis is there, it's all right, that is there. Why she has for 1 day solid, second day, third day, fourth day, fifth day, sixth day, up to 6 days or 7 days, she has kept mum. And she knows, and it is her version that mate protection there also things. On the second day or third day, when she was not under lock and key or not confined, it is well expected on her part to go and report the same thing or pray or request the same thing before the police station. She had not done so.
Okay, we'll continue after lunch. And in the meantime, if you that J juvenile case. Not.
Before the sessions come.
Oh.
And appeal has been preferred before the children's court of that area.
So it's not a case of acquittal.
No. Acquittal is in say 302.
In 302. No, do you want to see that
obviously
evidence
because
of PW1? So, which court it is pending now?
Fourth additional session judge Raigada.
Fourth additional session judge.
Okay, Raigada. Yes, fourth additional district judge Raigada. Fourth additional district judge it has been the
session judge.
Session judge Raigada.
Raigada. Number hochi 186 of 2018.
Registration number 8 of
Criminal appeal. Criminal appeal 186 of 2018. The appellant name is Jamsu, J-A-M-S-U, Jamsu Sabar.
J-A-M-S-U,
my lord. Jamsu Sabar.
S-A-B-A-R.
My
lord. What is the court in which principal magistrate JJB court here? ଆପଣଙ୍କର ଏଇଟା ତ ପଳେଇ ଆଇଲା ସେଠିକି
ସେଟା ଆସିଲା
ଏଇଟା
ଜାମସୁ ସବୁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କ୍ରିମିନାଲ juvenile case number 6 of 2017.
Juvenile case number
6 of 2017. It was in the file of corresponding to city case number 8 of 2020.
City case number
8 of 2020. How it will be? 16 মানে হবনি
না 8 of 20 কেমতি হব
হবনি ଅଛି କିନ୍ତୁ ଯୋଉଠି କମ୍ପ୍ୟୁଟର ରେ ଆସୁଛି
no 6 of all right we do you will do one thing we'll just call for the trial court record from that inquiry that this fourth additional session judge that LCR of that
everything
case.
will be there everything yes my lord everything will be there deposition everything will be there
evidence part the submission is to child who is inclined to peruse the
evidence of another either one that's all. Considering the submission they are inclined to call for the record from the session.
8 of 2018 8 only 8 my lord 8 of the year 18 this part is right one
2018
ଆଜ୍ଞା appeal ଟା ହଉଛି 18 ର
evidence of
eight again 8
First find out sir.
only 8 my lord it is in there the register my lord the
filing number is
filing number is 186 thereafter criminal 8 no, appeal number 8 of 2018 my lord pending the file of 4th additional district judge.
Appellant ନାଁଟା କଣ କହିଲେ? ଜାମସୁ।
ଜାମସୁ ସାବ JMFSU।
ଆଚ୍ଛା ଗୋଟେ ଏଇଟା ଆମର ଇଏ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲକୁ ଟିକେ କହିବେ।
High Court. Melita Sahu examined as PW1 and PW1. Procedural PW1. Informally on bracket.
ଆଇଓର ଏଭିଡେନ୍ସ ବି ଥିବ। ଆଇଓର ଏଭିଡେନ୍ସ ବି ଥିବ ସେଥିରେ।
ଆଇଓ ଏଭିଡେନ୍ସ ଦରକାର
ତ ସେଥିରେ ଥାଇପାରେ।
ଆଚ୍ଛା ଆଇଓ ନାଁଟା କଣ ଶୁଣନ୍ତୁ ଆସୁଛି ତ ଦିଟା ପଳେଇ ଆସିବ।
ଆଜ୍ଞା
ଜ୍ଞାନେନ୍ଦ୍ର କୁମାର ସାହୁ। ଜ୍ଞାନେନ୍ଦ୍ର କୁମାର ସାହୁ।
His name is ଜନେନ୍ଦ୍ର କୁମାର ସାହୁ।
ଜ୍ଞାନେନ୍ଦ୍ର ପଢିବେ।
ଜ୍ଞାନେନ୍ଦ୍ର କୁମାର ସାହୁ ଆଇଓ ଖବର ଦେଲେ ଆସିଲେ ମୁଁ କହିବି। Yes, you continue. Just RG confirm me. She confirm me.
As was, I was trying my best to give a picture before this one will quote that the veracity of PW1, because that is the crux of the matter, and if I don't believe that, then definitely.
Just 1 minute. What is the date, next date of posting of this criminal appeal?
The 3rd of May 2024.
Okay, now you proceed.
Back. The PW1, my lord, why she has kept mom for these intervening 7 days, as I was already submitted before, my lord. It is definitely on 9th of 6th, because of the threatening, there was some reason which can be believed that, in fact, because of these threatenings, he was not in a position to move forward, even though such a alleged ghastly crime has been committed and 3 persons of our family has been brutally murdered, my lord. And on 10th morning, if I take note of the story of there was a meeting convened, although that has not been substantiated further and evidence has not been brought out by the prosecution by any means, that in fact there was a meeting.
Please.
So, as I was submitting, my lord, in fact, there was some reason to believe that it because of the threatening on 9th 6th 2016, there in the night, she has not came forward to approach anybody for registration of the affair, although the police station admittedly is around 3 kilometers away from our place. And on 10th day morning, although that part is not proved, that in fact whether there was a meeting or there or not, but on 10th also there was some sort of threatening to her not to move forward. But from 10th to 16th evening, well, a clear cut of 6 days is there. If during this particular period, her presence anywhere, and her admitted position is that she has not been detained by the accused appellant or anybody else, or she was not also pressurized by any person, and no further threatening was given to her. So under this intervening period of 6 days, her silence is quite suspicious, and This, if my lord take note of this aspect, that why she has kept mum, it is not a thing that any small thing has happened to her. The entire life of the girl was, my lord, taken away by the alleged overtact of the appellants. So by the process, why she has preferred to keep mum. And during that particular 6 days, there was also no continuous. Had it been a case that there was a continuous threat, then matter would be something different. Yes, of course, it was there on 9th and thereafter on allegedly on 10th morning. And even if this threatening was there, that the life of the girl will be taken away or the brother will be taken away, these facts vis-a-vis we, my lord, the my lord, my lord, on the contrary, if my lord take note of this threatening and the other loss she has, my lord, made during this particular period, I think my humble submission is that it is quite common on the part of the people want to come forward and to depose all such things before the police. Of course, I do consider that depending on the mindset of the person, it differs. I don't dispute that. But it is not such a well, small thing which can take away the mind of the concerned girl not to go and depose it before the police station. And because the fact that the police station is also not with a far distance, so that there is a possibility that if in between if the appellant may restrain him, restrain her. So it was also quite thing, not a fact that also it is not on that ground she has not approached the police station. So these 6 days under 134 Evidence Act, sole, I do consider sole testimony is also a time sufficient. But whether this evidence, which is allegedly admittedly developed from time to time, and the prosecution has also not come forward with a clear picture of examining the witnesses, can be the thing which can trustworthy, which can take the shape of the evidence against the nine appellants for the alleged act. This is the subject of matter of constitution of this honorable court, my lord. And because of the fact, as I pointed out, that she has developed the case, if my lord take note of from the affair, from 164, from the court of deposition, all these submission, this story of her evidence that on 15th there was a So all where Smellat she has developed the case, and this development also created doubt because of the fact that she has said that on 15th the dead body was recovered from the graveyard, and subsequently it was cremated. So my humble submission during spot visit also, and although it is the case of the prosecution that after the after killing the dead body was dumped inside a ditch, and sand were also used for to bury those things, my lord. the ditch mallet wherein they have been buried mallet, spot visit that is silent. Although spot visit, cremation ground has been found and the place of our alleged cow shed was searched, but the search team has also not found the place wherein the dead body was allegedly buried and followed by the sand was used.
Cremation.
No, sand was used to cover it. Nowhere this spot in this spot has been found. So if I had found that this particular aspect is not come out from the evidence from any person, including the IO, my lord, the IO is also silent about the particular place of burial because at the possible the prosecution murder subsequently buried thereafter cremated. So the spot map, the IO, and everything else were silent about the place of burial. And in the burial also no sand anything else been found. And if, as it was pointed out by my friends, that a body after being buried for the dead body after buried for 5 days, definitely there will be physical changes. Decomposition starts, and during decomposition, many body parts of the body will come out, which will come out, will be decompose, and in the say many chemicals like substance will come out, and it will definitely this sand and everything will be it will be part of the body components. And because of the fact that there is no such burial, so no such thing has also been found from the burial ground or the place of where it has been allegedly buried. So if that is so, my lord, this story of getting the information regarding cremation on 15th itself is a developed one. So my humble submission, these things has been only planted or used only to see that the delay which is admittedly there, that will be covered up, and at least a believable story can be presented that why she has kept mom just to for this intervening period. So my humble submission, if that will be taken care of, and if my lord ignore that in fact there was, because the fact there's no burial, and on the day itself the cremation was there, then definitely this presence of the middle one at the scene of occurrence will be my lord totally my lord process. And
So, what you just said now, that since the place of burial has not been shown in the spot map, and there is no evidence that any earth was dug from that place, then this burial theory.
There, as per the prosecution case, there was a dig, earth was digged on a particular place, but no subsequent clue is there. The body were buried there. It was there. I don't dispute that, but spot map doesn't say so. Although it has been said that there was a the earth was on a particular place with 10 feet of height.
That was for some other purpose.
That exactly I want. And the story of the body was taken away. It was kept there for 5 days, and by implies sand, it was covered up. These things was not there. And if I would take note of this aspect, that in fact that was not there, the subsequent development of the informant to the aspect that the body was taken away, and by the process it was set fire. This will go.
Yes.
And because it was said that only on coming to know about this setting of fire, and after the body was taken away from the particular place of burial, my lord, it will go. And this has been planted only for the purpose to see that the latches or the lacuna on the part of this informant
delaying lodging the FIR is
to
got
be excluded. That is the reason, and it has been subsequently only been planted only for that particular purpose, nothing else, my lord. And besides this, my lord, the IO in his cross-examination has also admitted to the occurrence to this aspect that it is a fact, para 54, it is a fact that there is no eyewitness to the occurrence, only one part, the subsequent part, only the accused persons and deceased were present in the scene spot of occurrence, that is the cremation ground. So admittedly, it is the case of the prosecution that I haven't accept these Procedural one, not a single person are the witness to the occurrence.
So that his investigation reveals that.
Investigation reveals that.
Okay.
So, but in fact of such a crime, admittedly, I do consider that many persons will not come off to depose things in this particular aspect because of many reasons. But things remain, my lord, as because of the fact that it was also duty of the prosecution at least to examine some persons of the nearby locality for the particular purpose. At least in the charge sheet also.
No, provided that any houses are there,
my lord,
in the vicinity of the burial ground, then matter would have been different. If say during the night on that particular day everything happened.
My lord.
So if that is the thing, then how do we expect that the many, at least some persons would be there to nobody knows that what is the church timing, when it was getting closed. So that cannot be, and you have not brought it out either in the cross-examination or through the evidence of the investigating officer that near that place of burial there are other houses in the close vicinity, so that you can would have advanced an argument.
My humble submission, since I do consider that from the mouth of this investigating officer, the defense has not brought out all such things, but from the mouth of the Procedural one, it has been come out that there was 25 houses and this church was in between.
No, church टा अच्छी बोले तो spot map ही देखो 25 25टा घर आम गाँ रे अच्छी से एया कहले ता माने नुहे जे से 25टा घर से जो burial place पाखे
अच्छी कोई मजा मजी अच्छी से कहले the exact word is that it was in between
his house.
तार घर कोठी से घर कौन है
that part that is not specific part that is not there. The possession my lord para she said so too. And besides
in that extrajudicial confession, which is in the 164 CRPC statement or in the court, is there anything that after committing the crime they buried the dead body?
No.
164 तो नहीं
नहीं
जो PW1 जो कौची तार कोर्ट एविडेंस रे एक्स्ट्रा जुडिशियल कन्फेशन विषय रे जो मीटिंग रे
whatever she has said, the court ballot is just a development, and the IO has also
just 1 minute.
And come to the page, para 7. Para 7.
Para 7 of car.
See, you 164 रे जोड़ा पूछंती. Page 97 रे.
164 97.
मेरा.
हाँ.
ସେଇଥିରେ ସେ ଅଛି ପୋତିବା କଥାଟା ଅନ୍ୟମାନେ ସେଠାରୁ ଫେରି ପ୍ରାୟ 9 ଘଣ୍ଟା କିମ୍ବା 9 ଅଧେ ସମୟରେ ମୋ ପାଖକୁ ଫେରି କହିଲେ, ମୋ ବାପା ମା ଓ ନାନୀଙ୍କୁ ଆମେ ମଶାଣିରେ ଟାଙ୍କି ବସିବା ପାଇଁ ଖୋଳା ହେଇଥିବା ଗାତରେ ମାରି ପକେଇ ଦେଇ
କୋଉଠି କହିଲେ?
ପାରା 7 ମାର ଲାଷ୍ଟ ପାର୍ଟ ପେଜ 97 ମାର 97 ତଳୁ 97 ଅନ୍ୟମାନେ ସେଠାରୁ ଫେରି ପ୍ରାୟ 9 ଘଣ୍ଟା କିମ୍ବା 9ଟା ଅଧେ ସମୟରେ ମୋ ପାଖକୁ ଫେରି କହିଲେ, ତୋ ବାପା ମା ଓ ନାନୀଙ୍କୁ ଆମେ ମଶାଣିରେ ଟାଙ୍କି ବସିବା ପାଇଁ ଖୋଳା ଯାଇଥିବା ଗାତରେ ମାରି ପକାଇ ଦେଇ ବାଲି ପୋତି ଦେଇ ଆସିଲୁ।
What is there in the court evidence?
In court evidence, my lord,
that is which paragraph? Paragraph number 3.
Incident. To cover my father, then the
No, we are concerned with that particular thing about that the dead body was buried.
is not body elder.
Para 6 I learned 16th September I came to know.
my lord, para 6. One ditch was dug by JCB machine for construction of a water tank, where it was learned that they had buried the bodies.
On 16th, I came to know that accused person brought out the dead body. Parents also from the beach where they had buried son. This becomes the hearsay evidence.
Well,
question is,
he has not seen.
No, when काटू सुनला कौन हला किछि नहीं ये जो subsequent जेनु बरियाल आउ ये जो तक बाहर करी कि नि पोड़ीबा या पई हमकर एविडेंस कौन अछि ये जो
मु आसीबी
because that is one of the aspects of the prosecution case. And if PW1 has no personal knowledge,
yes, exactly,
right? So by other
that
evidence,
is there. There is no personal.
by other evidence, you are to substantiate that aspect also, right? Yes.
So admittedly, this aspect, as has been pointed out by Lord, that had there been no such aberrament, that in fact there was a cremation of body after it was brought out from the dig mallet or the burial place, this affair, the existence of affair, should have been thrown out at the very threshold. And this thing has been planted or this projected just to see that the delay will be explained. So my humble submission is 134 evidence are clear to the extent that testimony of the solitary witness is the requirement. Also can convict a person, and it is the quality, not the quantity. But my humble submission under such circumstance, the evidence, because of the fact that the presence of the victim at the scene of occurrence, vis-a-vis absence of light and or to watch the things in a specific manner from a ray of light coming from the house of Bubun, and this particular house of Bubun also, whether it was there or not, and the revenue authority has also not been compromised or examined to that aspect whether the house of Bubun was also there in fact in the not or not. So her claim of witness in the pitch dark night of the day of occurrence is doubtful. And furthermore, as she has developed the case from time to time, in the affair she has said something, it has been developed in the 164 statement, it also developed in the court deposition before the court, and the persons allegedly who have given the threat at the very initiation, those persons who have not been charge sheeted, or they have also not been subsequently brought an accused under 319 also cast a doubt. And because of the fact that almost all the persons witnesses to the prosecution, they have said that because of cholera thing has been materialized. The probable plea of the defense that things might have been done in that aspect, and because of the previous enmity which was there, and if I have take note of in the IO has said there was some dispute relating to the land that is there in the evidence that was there, and the persons are claiming share on the ancestral property. Because of that things, after the things was over and after this body was cremated, much after this thing has been highlighted or projected or planted, just to see that the previous enmity or previous ill feeling what was there, it will be materialized. And to that effect, things have been planted and this Pedal 1 has been utilized.
Okay. So that means the last submission was that since he has made time to time development in the in his person, then she cannot be said to be a truthful or absolute reliable witness. See, her version in the FIR is developed in the 164. To some extent, it is developed in court, all these things. So it cannot be.
Her version are also not corroborated by any independent witness.
No, that is nothing. Nothing is there.
And her evidence also has not been corroborated by the Pedal 11 or at least the SFSL team. Because had there been any story of this burial was there, at least they could have would have get something from the particular place of occurrence. Of course, it is the case that after they are taken away, they will definitely, because it is the case that when they have been murdered, assault was there, and in the process of assault, there must be some bleeding, some sort of things of the body of the physical thing, biological things to come up, and by the process, at least there, where is their dresses? Of course, it is the case that the body has been cremated, but where is the dresses of those deceased persons? If it has been burnt out, it's all right, and it is the case that by the lathi and the other things by the process of fire it can be put to turned to ashes, but the bucket was utilized, and it is the case of the prosecution the bucket if it has been burnt and on the all day, and the syringe which was utilized, the plastic material must be there in the ashes those things has also not been found out by the so this story of using bucket which has been utilized to see that things will be highlighted, and by the process the crime will be horrified, and to see things will be put to their interest these things has been developed to that effect. And furthermore, as admittedly in the particular case, the IO, who is the best person, has also admitted to the fact and many persons which requires a proper investigation has been left out. I don't dispute to the fact that because of the latches, I am not get any benefit. But an adverse inference can be done against the prosecution case, which will definitely entail at least a benefit doubt to the appellants. So by the process, the many persons who are admittedly, as per the prosecution case, they are the author of the crime, the persons who have threatened, the past person, the person who have been called the Pedal 1 to the early spot of occurrence, even if had it been there, then it is her evidence that when she was brought to that particular place, that particular person said, I have brought her, tied her. The exact word, So definitely because of this, definitely he is the author of the crime. The other two persons who have guarded her at the scene of occurrence, those two persons are also the author of crime. The person who have subsequently assisted by the process of
Mr. Chan, just please. hearing, it is brought to the notice of this court by Mr. Manas Chand, Land Council appearing for the appellants in CRLA number so and so, that the juvenile, so the juvenile faced trial in before the principal magistrate JJB, and though he was acquitted of the charge under section 302 of the Indian Penal Code, but found guilty under other offenses, and he has preferred an appeal in the Court of Session, which has been registered as CRLA number 8 of 2018, and the same is sub judice in the Court of London, 4th Additional Session Judge. Additional support would be very much necessary in the interest of justice, and the same may be called for. Let the registry call for the same and put up tomorrow.
Maybe the copy of the deposit may be supplied to one line.
After the receipt of the deposition copies, the same may be supplied to the London Council for the state as well as London Council. Oh.
Much obliged.
Juvenile case theater.
Yeah. Just correction. Yes. Mr. Chand, you proceed.
And so far the other aspect is concerned, my lord, with all such legal latches, when the learned trial court has not taken care of the admitted position, admitted factual aspect, and as if hold in his entire judgment has hold that there was two occurrence, although there was no such two place of occurrence. In fact, the prosecution, even if taking note of the evidence of Schedule 1, and which has also been supported by Schedule 11, that the place of occurrence, as has been found, as has been available, is only one. Because the Schedule 1 has just said there is no material regarding the second part of occurrence or the second place of occurrence. So my humble submission for the court, while passing the final judgment or even while on hearing of sentence, has said that there is in fact two occurrence, two place
Taken to the second place of occurrence.
So this the wrong conclusion.
No, you mean to say that there is no legal evidence that there is any second place of occurrence?
Not only ocular, but also supported by the spot visit report. Spot visit report also, they have not found any place of burial.
Anything that would show the decomposition of the dead body.
The ocular evidence may differ from this place to this place, but so far the scientific report will definitely, expert report is much trustworthy than that of the ocular evidence.
Some burnt pieces of bone collected from earthen hole, as per the report of the scientific officer.
My humble submission, the earthen hole of place where it has been found,
maybe that where the body
part
was
of the burial, it is a part of the burial place, not from the deep.
I want to clarify, my lord. Kindly come to page, my lord.
Perhaps there is a single place where the bodies were buried and the earth was dug, and thereafter at the same place the cremation was.
Come to place 348.
Maybe that
348, my lord. Page 348.
348,
my lord.
Yes.
The spot taken there also, my lord. Cremation ground, next, the below of cremation ground, the burial place, my lord. Just adjacent to the, just up and down, my lord. 348.
Both are different places, sir.
One place
Cremation and
place
place where the bodies were buried.
buried, my lord. And the cremation is just near to that.
No, cremation ground is there.
Cremation ground, that
It is
cremation.
shown as a cremation ground.
हाँ, cremation जोड़ी cremation थे. ସେ କହୁଛୁ ଯୋଉଠି cremation ହେଲା ଯୋଉଠି ପାଇଲେ ସେମାନେ bones.
ଆପଣ ଦେଖେଇ ଦେଇଛନ୍ତି ମାନେ ନୁହେଁ ଯେ ଏଇ ଜାଗାରେ ହେଇଥିଲା. But what is the material?
Area of cremation, my lord.
ଆପଣ ଗୋଟେ spot map ରେ ଦେଖେଇଦେବେ ଏଇଟା ହଉଛି cremation ground, ଏଇଟା ହଉଛି burial place. ଦେଖେଇଦେଲେ
burial place ଯୋଉ scientific ଯାଇଛନ୍ତି ଯେତେବେଳେ
ସାଇଣ୍ଟିଫିକ ଅଫିସର କଣ ଦେଖେଇଲେ ଯେ ତିନିଟା ବଡି ସେଠି ଇଏ ହେଲା ଆପଣଙ୍କର ଡିଏନଏ ଟେଷ୍ଟ ରିପୋର୍ଟ ଆସୁନି.
ଲିକ୍ ହେଇଥିଲା ଯୋଉ ଜାଗାଟା ଖୋଳା ହେଇଥିଲା.
Burnt pieces of bones have not been collected from the cremation ground. It has been collected from earthen hole. ମାନେ ଗୋଟେ ଡିଚ୍ ଭଳିଆ ଗାତୁଆ ଜାଗାରୁ କାଢିଛନ୍ତି ସେଟା. ଦେଖନ୍ତୁ kindly come to page 344. Ashes, same spot. Where it has been mentioned that the bones have been collected from the cremation ground.
My lord. Page 343, my lord. 343. The cremation area were full of ashes, burnt bone pieces, and residue of the burnt wound pieces in warm conditions.
Burnt wood pieces.
କାଠ ଜଳିଥିଲା. The area surrounding it was found in a warm condition. During search, fingerprints are not found, my lord. One of the
bamboo stick,
that is there.
Such and such.
What is the time of visit?
The time of visit, my lord.
That is date, time, dimension anywhere.
My lord. 17/9/2008, my lord. Timing.
Previous page 341.
Continuing.
My lord, may see date and time of departure from the such and such.
12 p.m. and 1 a.m.
Scene of crime, column number 5.
Can the ashes be found in a warm condition if the bodies were cremated on 15th? 15th cremation hela. Still there was warmth while collecting the ashes. When the spot inspection has been held on 17th, almost 2 days after.
You are making a submission that that was not the cremation ground at all. But as it appears that it was
founding that is
ମାନେ ଅନ୍ୟ ମଧ୍ୟ ବଡି ସେଠି ପୋଡା ହଉଥିଲା.
Recent cremation maybe.
Recent cremation ମଧ୍ୟ ହେଇଥିବାର ଆସୁଛି.
That has not brought any anywhere.
ନାଇଁ ଗରମ ଅଛି ମାନେ obviously within ପର୍ଯ୍ୟନ୍ତ how do you say
106 was pretty ବର୍ଷା ନେଇ 106.
That apart, the scientific report does not conform to the DNA profile.
DNA
zero.
କାହାର bone sir ସେଟା?
ଏତେ ଲୋକ ପୋଡା ହଉଥିବେ ତେଣୁ ଗୋଟେ ବୋନ୍ ଆପଣଙ୍କର କିଛି ପାଇଗଲେ ସେ ବୋନ୍ ଠାରୁ ଯଦି କିଛି ନ ମିଳିଲା କନେକ୍ଟିଂ ଲିଙ୍କ ନ ମିଳିଲା ଆପଣଙ୍କର ଯୋଉ ସେକେଣ୍ଡ ପାର୍ଟ ର ଏଭିଡେନ୍ସ ପାଇଁ ଲିଗାଲ ଏଭିଡେନ୍ସ କଣ ରହିଲା ସେ PW1 ଦେଖିନି ଆପଣ ଯୋଉ ବୋନ୍ସ ପାଇଲେ ସେଟାକୁ ଯଦି ଲିଙ୍କ କରି ହଉନି ତାହେଲେ ସେଇ ଜାଗାରେ ପୋତା ହେଲା ତାପରେ ତାକୁ କାଢି ପୋଡା ହେଲା ଏଇ ଯୋଉ ପାର୍ଟଟା particularly we are harping on these two parts ମାନେ ତାର legal evidence କଣ ଖାଲି except ଶୁଣିବା କଥା ଛଡା
ସେଇଥିପାଇଁ ଆଜ୍ଞା ସେ ଯୋଉ ସେକେଣ୍ଡ ପାର୍ଟ ପାଇଁ ହିଁ ସେ ଡେରି କରୁଛି ବୋଲି କହୁଛି ଏଫଆଇଆର ଟା ସେକେଣ୍ଡ ପାର୍ଟ ଜାଣିଲା ତାପରେ ଆସି ଏଫଆଇଆର ଟା କଲା ଏବଂ ସେଇ ପାର୍ଟଟା ଯଦି ଶୁଣିଗଲା ତାହେଲେ ତାର ଟୋଟାଲ ସାଇଲେନ୍ସ ହଉଛି ଫର 7 days. If my lord exclude, if my lord include that, yes, in fact, there was a such things of set cremation after it was buried, dead body was brought out from the river. Then definitely these 6 days there was something things were there, and if that will go, then she has kept silence for entire 7 days. And in the spot map, as has been shown by my friend, my lord, the place of burial and the place of cremation was two different and distinct things. My lord, page that is 349. Burial is right side. Burial
right name. burial area of cremation and burial. Yes,
The area of cremation is there.
Ah,
Thereafter, in the 15 feet
15 feet
away from a particular place.
No, 15 feet no. Total area 15 feet. Area cremation
feet
and
to 10
burial.
feet.
Total area जो round
15
question that is 15 feet.
15 feet to 10 feet.
10 feet जोड़ा 15 feet. ता भीतर दीटा का cremation ground and burial ground. Both are
there is no specific evidence that the bodies were physically lifted out of the burial ground and taken to the cremation ground and burned. ସେମିତି କିଛି evidence ନାହିଁ.
There is not that.
ଖାଲି ତ ସେ ଗୋଟେ ଲାଇନ ହଉଛି ମୁଁ ଶୁଣିଲି ଆଉ କଣ।
ଶୁଣିକି
15 ତାରିଖ ଦିନ ଶୁଣିଲା ନା 16 ତାରିଖ
15 ତାରିଖ
15 ଶୁଣିଲା 16 ଏଫଆଇଆର ଦେଲେ।
ହଁ 15 ଶୁଣିଲା 16 ଏଫଆଇଆର
15 ଦିନ ଶୁଣିଲି 16 ତାରିଖ ଏଫଆଇଆର ଦେଲେ। And if that will go, my lord, definitely the stand of the accused person will be much better than that of the present one.
Let's come to the next point or anything if you want to.
And as I have already submitted, my lord, and the role of the investigating officer during investigation is quite doubtful, my lord. And on the one hand, he is saying that he has joined on 14th, and it is also a specific question was put to him that there was a news publicity, all such things was there. He has not taken care of all of such. Although that is late, I don't dispute the fact that at the relevant time when this question was put to him, at the relevant time it was not no occasion on his part to go into all aspects. But when thing has been there, it is also his responsibility to see that things will be in a proper manner. And he has also not examined the persons who has allegedly supplied, because these things were there in his evidence or in his investigation, that these injection or the pesticides was purchased from a nearby shop, and the pesticides in a particular shop, and the investigation is silent from whose shop
we have noted now.
And thereafter also the owner of the particular person has not been examined. And one thing, but the presence of the petrol one, where she was, as I pointed out, that is also to be taken care of. And when she has lost the affair, it is his specific horse evidence that she had been to the police station with a particular person, but that particular person has turned hostile. And the scribe of the affair has also not been examined. And all such things, if not taken into account, then it's a case where the things has been developed, planted, and the executed version also support to my contention that with the sole intention to prove these persons for the alleged commission of crime, the case has been planted. And with this solitary testimony of the evidence of the Pudal one, will not come to an irresistible conclusion that it is the appellant who have committed the crime. And as Malad has pointed out, my friend, that the mitigating circumstance and the aggravated circumstance, as has been pointed out by the judgment, Malad, take note of that. I want to submit on that 2 lines on that, Malad. Judgment para, while hearing on sentence. Wait, 87. Clause 3. The offense was committed because the condition which has been prescribed. The offense,
which page, please?
287A.
Hmm.
The offense was committed with the intention to create a fear psychosis in the public at large. And was committed in a public place by a weapon or device which clearly could be hazardous to the life of more than one person. So my humble submission, the offense was committed with the intent first. And if my lord also add the evidence of the Pedal one to this aspect, that there was injection was used for the purpose of with the pesticides, my lord. But definitely those things, lathi, slaps, kicks, and this.
No, Mr. Chand, it was pointed out by my esteemed brother that it is not that no other circumstance can be the aggravating circumstance except as enumerated. They have just given it out for by way of an example they are given. So other
The
things
said
can.
circumstance doesn't apply.
Yes.
Honestly speaking,
Oblige,
said
oblige.
circumstance doesn't apply.
Yes.
And the next matter, the weapons and weapons used are also not up to that, which clearly could be hazardous to the life of more than one person. This aspect. And one thing I have to take note of, that admittedly it is her evidence that 7 except the father was found with bleeding injury when he was taken away from the cow shed. The two other persons were not having any injury. 7 except one piercing injury that will be there. And the mother has also found with no injury. And her evidence, on the contrary, it is specifically in the deposition, also in the statement, evidence has said that they were assaulted brutally by means of
both the conditions have to be read together. Weapon or some kind of a device used while committing the crime. And the first condition is that it is in the public eye. It is not taking place at a public place. So therefore, the said circumstance doesn't apply, sir.
And the next oblige for that. And the next one is 9. When the crime is enormous in proportion, like making an attempt to murder of the entire family or member of a particular community. So this will also not be there because had there been an intention, they would not have spared the
PW1.
vis-a-vis the other two persons who are although they were not present at the particular things, but things might have been done in any other way, my lord. And the second part is that particular community also is not there. That is also no evidence, my lord. So if this will go, none of the clauses of this aggravated circumstance will applicable so far the present case is concerned.
Yes.
In contrary, my lord, this mitigating circumstance, rather the mitigating circumstance are definitely in favor of the present appellants. Age of the accused, relevant consideration, but not determination, they will fact there. So the age of the group are also coming under a particular 21 to 42. 27 42, my lord. The next, the chances of the accused of not indulging in commission of the crime again, and the probability of the accused being reformed and rehabilitated. My humble submission, because the fact that there is absolutely no case pointed out as against those persons, 8 or 10, 9 in number, and they have also no previous antecedents of any nature. This sentence, death capital sentence, is too harsh and not at all reasonable or justified so far the taking into account their previous conduct or that they have no previous criminal antecedent. And chance of reform, although it depends on the fact and circumstance, and nobody can predict about the reform in future if a person there, but taking into account their previous conduct, that during this particular period of 27 years or 42 years or like that matter, they have not indulged in any criminal activities. So if this offense, the capital punishment will go, definitely there will be no harsh to them, and definitely chance of anything recurring commission of the crime once again, it will be not there.
If there is a possibility of reformation rehabilitation,
the
act is so gory, ghastly crime, it would outweigh
perhaps
the mitigating circumstances.
Perhaps my humble submission that this particular clause has been introduced, that after serving for 14 years like that, if a particular person be come out, then whether they really relevant, perhaps my lord, legislature while enacting all such things would have been in their mind, because the period generally it is around 14 years or 15 years like that. Suppose after coming out, whether they will commit this crime or anything else, or the same repeat the things, for us it was in their mind. That's why they have introduced or reflect this. So if they believe that is there, my humble submission, because the fact that the appellant, none of the appellant have any previous antecedents, these things can be utilized in favor of the appellants. And so far 6 is concerned, where the court upon proper appreciation of evidence is of the view that the crime was not committed in a ordinate obtained manner, and that the death resulted in the course of commission of another crime, and that there was a possibility of its being constituted in consequence to the commission of the primary crime, it is not applicable. And last one, where it is absolutely unsafe to rely upon the testimony of the sole eyewitness through prosecution has brought home the guilt of the accused. This one is important, my humble submission. Because here the case also, the sole testimony of the prosecutor, if it will go, so definitely, my lord, the only way out is the acquittal of the present appellants, my lord. And this sole testimony of the prosecutors, as the prosecutors has kept mom for 7 days. No, none. She has not. It is. She has, but saying, behaving in an abnormal manner, I can say. She has kept mom for 7 days without, which is not at all common for a human being to keep silence with such backgrounds, with such ghastly act allegedly occurred with her. So when she has kept mom for 7 days and her version is not free from development, and each and every time she has tried to develop the case.
That submission is for acquittal, sir.
Yes.
This submission is for conviction.
No,
if
yes,
there is a conviction,
no, yeah, my humble submission, the
charges have been proved. Even then also, if the evidence of the sole witness is not worthy of acceptance,
the court
there may not be a death sentence. That is one of the mitigating circumstances.
That's my humble submission. So this testimony of this particular PW1, if my lord will not believe right at the moment because of my submission or because of the fatal circumstance or because of the evidence, then the court open is the acquittal.
Here perhaps what it is stated that in a case where apart from the sole eyewitness, there are other evidence on record, but court finds that that sole eyewitness is not absolutely reliable, but in view of the other circumstances, other evidence, the guilt of the accused is proved. Right? Maybe circumstantial evidence. So there, it would not be safe to impose death penalty. Sole eyewitness would be there,
but still
that is not absolutely safe. But in view of the other circumstances, the chain is completed or something like that. So that guilt is found out. So in that case also, that is
mitigated.
Yeah.
And here the case where no corroboration from any side.
No, it is not there. Here
so my humble submission, taking note of all such aspects, and it's a case where my lord to interfere, and the death penalty, not only the death penalty, the life punishment is also not sustainable.
But it is likely to continue tomorrow, of course. So you in the light we have stated to him, just find out a decision where for this type of purpose multiple murders are committed for witchcraft suspecting. So what is the analysis of the Supreme Court? Yeah.
Instead of tomorrow, my lord, maybe on Monday, so that my lord will get it the
no, it is just coming. We are just supplying to you.
Then solid. Then
we are just supplying to you. It's just coming. Don't. Yes.
Let
so,
my friend.
Before going to start, my lord, the incidents occurred. It is to be kept in our mind, my lord. The incident occurred before a tribal girl of age about, my lord, 17 to 19 years old, my lord. And unless until we put ourselves in that situation, what would be the mental status and the fairness at such type of incident occurred in our front, my lord. So keeping in that, my lord, in view, my lord, the fear psychology and the fairness and the state of mind, the trauma is going on the girl, my lord, of 17 to 19 years old, my lord. We have to take a decision on the entire prosecution case and the testimony of the PW1 matter.
She stated her age to be 22 years.
22 at the time. 20.
When she gave her 164 CRPC.
My lord, that is
there in page 90.
My lord. 20 years.
Yes.
My lord. So there is a tribal girl, my lord.
Well, that is
My lord.
Yes.
So at that time, the situation and the surrounding and circumstance of the entire scenario, my lord. And from the evidence of the People One, they have also brought out the defense that there are only 20 to 25 houses are there in the village. That is not a big village.
Right. That is also correct.
And the out of the 25 houses, my lord, the involvement of the crime, as per the allegation, my lord, there are 10 persons are there already convicted or have been accused, allegation is there, and 2 other persons not been made accused in this case. Means it is 12 or 13, or if it will take 12 to 13 people are already involved in a crime where the village people are houses are 25, my lords. So
Maybe it may be 7-8 houses because somebody's son is also there,
yes, my
brother is also.
lord.
So it is the family of 7-8 persons are involved. So yes,
9%, my lord.
yes.
Only 2 brothers are there. Others are, my lord, different. My lord. So my submission is that in a small village of 25 houses and this type of occurrences took place, and a girl to whom they inform and he reached the spot and saw the incident in such a way manner, the way they torture, the way they assaulted to her parents, my lord. That type of, even though someone not given any threaten, my lord, the fear psychology, seeing this type of occurrence involving a lot of people, that also continue for a trauma or for a time being, my lord. Not one day or 2 day it will come down. It lifelong he will cannot forget all this scenario, my lord. So at the time of adjudication, my lord, my submission is that to consider all the aspect surrounding and the situation at that moment, unless until we put ourselves into that situation, my lord. So taking into that consideration, my lord, the delay in lodging FIR, that 6 days, 7 days delay, my lord, that is also coming on that, as because he was on trauma, what she will do, what he will not do. He is a one girl, and all the village people, those who are new to him, new to her, my lord. So he stayed one night. Someone told that you stay here. He slept there, my lord. Then, even though the prosecution could not brought out where he stayed, but he stayed in that area, my lord, village, where only 25 houses is there, my lord. And if we'll go to the FIR, lodging the FIR, my lord, he has mentioned that mu luchi kari asiki FIR dochi. Means there must be his mind that others are watching where she is going or not, even though no one is guiding him. But that few cycle is that mate ke dekhi devo ki muka pole. So say bahar se dhari jaunotla. So when he got information after on 15 mile that whether he has not seen, he got information from what source is different thing, my lord. That cremation has been done of his parents, my lord. At that moment, the state of mind of the girl, my lord, may have changed, and he ran out without any fearness, with a force, with the courage. He went to the police station and lodged the FIR, my lord. And my lord, if we will go to the constituent statement and the FIR and the 164 and the deposition, my lord, there are similar inconsistent, my lord, so far as the first incidents occur, my lord. Regarding the assault, regarding the that injection, regarding that small discrepancies are there, my lord. I'll come on that basis, my lord. So on that basis, the defense is not able to check the witness for the so far as the first part is concerned, my lord, regarding the incident took place, my lord. Before going to the contradiction, my lord, whatsoever, my lord, yesterday, my lord was asking me about the injuries, my lord. Their blood stain is not, external is that not. So on that point, I would like to draw my lord's attention to the Modi jurisprudence, my lord.
No, according to the PW1,
My lord,
her father sustained
sustained a bleeding in his nose, But so far the mother, no external injury. That I am clarifying. That I want to.
And in the chief examination, he has stated that she was assaulted. Mother
Mother
was assaulted, lathi, stick, and crowbar.
Crowbar matter. That's why I am keeping on that
By
on my
page-
lord. I am
Yes.
going to the Modi jurisprudence. My lord, can you come to page, my lord? My lord, page 686, my lord, Modi.
This is we are holding 23rd edition.
My lord.
Which edition you are?
I am, my lord, 23rd, my lord.
Then it's all right. Which page you are telling?
Page, my lord, 686.
Yes.
First, my lord, go to the medical classification of wounds, my lord. A. Blunt force injuries, which can be abrasion and contusion and laceration, my lord. And injuries caused by sharp cupping, my lord. My lord, now I'll come to the, my lord, next page, my lord, 687, my lord. The bruise and contusion, my lord.
Which one?
Bruise and contusion, my lord. This,
Yes.
my lord. Bruise or contusions are injuries which are caused by a blow from a blunt weapon, such as a club, lathi, whip, iron bar, stone, ball, fingers, fist, boots, or by fall, or by crossing or compression, my lord. These are accompanied by a painful swelling and crossing or tearing of the subcutaneous tissues without solution of continuity of skin. The swelling is due to the rupture of the small subcutaneous blood vessels producing in the cellular tissues. Extravasation of blood, which is known as ecchymosis. The terms effusion of blood is originally limited to extravasation of blood in a pleural cavity. Hematomas are found when large blood vessels are injured, my lord. My lord, next one. Ecchymosis makes its appearance over the seat of injury in 1 or 2 hours after the injury. It may appear in lesser time if the skin injured is very thin, as in the eyelids and scrotum. When ecchymosis has occurred in the deeper tissues or under tense fascia, it appears on the surface at an interval of 1 or 2 days or even more. At some distances from the seat of the injury, following the line of least resistance and in obedience to the law of gravity known as ectopic bruises. For example, the appearance of black eyes in the case of contusion on the forehead or on the head. Sometimes ecchymosis may not appear until after death. When a contusion has been caused a few hours or a day or two before death, according to the Sir Bernard H. Spilopri, this is not due to any appreciable addition to the blood in the contusions area after death, but to more rapid hemolysis of the stagnant blood as a part of the postmortem changes, my lord. Not equal then, my lord. My lord, then I come to the next page, my lord, 689, my lord. Result of bruise, my lord. Bruiser a rule simple injuries. They are seldom fatal unless accompanied by the rupture of an internal organ or an extensive crossing of the tissues and large extravasation of blood, producing sulfing and gangrene of the part. However, several bruises, though trivial individually, may cause death from shock, my lord. My submission is that, my lord, the assault has been by lathi or coward or, my lord, the father sustained injury from the blood bleeding from the nose, my lord. So there must be some injury in the nose, face, my lord, that is there. But the lathi assaulted by the lathi and robber and others, my lord, on the side of backside and the suppose in the backbone and suppose in, my lord, thigh and toe, in other parts of the body, which the deceased were at the time wearing the dresses, my lord. So at that moment, one cannot see whether there is external injuries are there or not, unless until there is bleeding cartilage, my lord. So that's the middle one told in para 10, my lord, that the mother has not sustained any bleeding injury and others, my lord. So assault is there, even though there is a bruise, my lord, severe attack is there, brutally assaulted, and he is continue telling that unconsciously they are, after they are being unconscious, they took away, and they are also assaulting after they are, my lord. So this part, my lord, that external is not that means that is there is not such type of assault is there, that one will die, my lord.
Another thing you can also say,
My lord,
that the time in which the occurrence took place,
in the evening, my lord,
and because of the paucity of
light also,
and particularly when these ladies might be wearing saris,
and everything.
so in that case, she might not have noticed whether any bleeding injury
is
has
there that also
sustained
there.
or not.
Even though that is not for the argument sake, my lord. So as because there is bleeding in the nose, he found that his father sustained external injury, but there is no facial bleeding from the mother's face, my lord. So he told that there is no external injuries there, and that part is there, my lord. The assault, brutally
But
assaulted.
your witness has stated that so far as father is concerned,
Yes,
he
ma'am.
has sustained
Certain
bleeding
bleeding
injury.
injury.
Their argument is that if bleeding injuries are there, blood must have on the ground. And if your scientific officer has visited that place or your IO visited that place, then obviously some kind of soil, if would have been collected.
My lord, on that question, answering, my lord. Suppose somebody gave a blow on my nose, my lord.
No blood matter is different.
So other parts is not there. Even though there is not external injuries, bleeding is there. How they will get blood from this test?
Your one witness at least received. One witness received in a place which is though cow said according to you, but there is no evidence that any cow used to be tied there thereafter. So if this place was there as such, and your officer, investigating officer visiting it, scientific officer coming to that, collecting different things from different places, including that place. So if nothing is found, bloodstains, so that according to them creates doubt that.
My lord, that's why I submitted, my lord. As per the Modi jurisdiction will take consideration, and the assault part is there that they brutally assaulted by stick or by the lathi, my lord. There may not be external injuries, blood injuries there. So the chance of getting blood from the earth is not, my lord, possible.
So there may be another point, sir. What useful purpose it would serve with reference to the medical jurisprudence when the bodies have not been recovered?
Exactly.
To anticipate
Anticipate.
what could probably the
Exactly.
injuries sustained by the
Exactly.
victims.
Exactly. That might, because there is no postmortem report, there is no medical.
Bodies are not available.
That is the only presumption, madam.
We have to presume that.
Yes, madam. That's
might
first type
have
of such type
received
of
such
injuries
injuries.
might have there. Exactly, madam. That's correct.
So the bleeding, what the witness says that she has not sustained any, her
External.
mother has not sustained any bleeding injury. That would not
Fatal.
improbabilize the assault part,
Assault part.
because in some parts of the body, if assault is caused by lathi, there might not be any bleeding injury, but there would be other injuries, and which might not be seen at that point of time because the ladies were wearing saris, etc. So that maybe.
Crowbar lathi used, and they've also become unconscious. That is the specific.
No, that he is advancing the argument like that. We are again harping. You are saying that so far as that man who has sustained bleeding injury and her blood must have fall on the ground. What about that? Yes,
Madam. Now, before going to the we have already, my lord, scrutinized the 164, 161, and the deposition and the FIR, my lord. I would like to draw your attention regarding the contradictions or omissions or additions of the. Before going to that, I would like to play some judgment, my lord.
you just pause and pause. Mr. Patnaik, this we are told earlier that was the practice since you are there. That used to be argued.
Number 41. Para 41.
What purpose for you are citing this?
Regarding the contradiction and omission and addition, my lord.
Which page?
PS, my lord, that is mentioned, my lord, that is para 41.
Para 41. Okay.
May I start, my lord?
Yes.
At a later stage of judgment, the learned judges laid down the following two test to ascertain whether a particular omission amounts to contradiction. 1. An omission is not a contradiction unless what is actually stated contradicts what is omitted to be said. Second, the test to find out whether an omission is contradiction or not is to see whether one can point to any sentence or ascertain which is irreconcilable with the deposition in the court. The said observations are in accord with that of a Madras High Court, so and so matter. The first provision to section 162.1 makes an exception in favor of the accused, but it is an exception must jealously uh, subscribed circumscribed under the provision itself. Any part of such statement which has been reduced to writing may in certain limited circumstances be used to contradict the witnesses who made it. The limitations are strict. The statement of the prosecution witness can be used, and 2. Only if it has been reduced to writing. 3. Only a part of the statement recorded can be used. 4. Such part must be duly proved. 5th, it must be a contradiction of evidence of the witness in court. 6. It must be used as provided in Section 145 Evidence Act, that is, it can only be used after the attention of the witness has been drawn to it or to those parts of it which it is intended to use for the purpose of contradiction. And there are others. Such a statement which does not contradict the testimony of the witness cannot be proved in any circumstances, and it is not permissible to use the recorded statement as a whole to show that the witnesses did not say something to the investigation officer. For para 42 in Sakawat versus Puron ILR 1937 277 must to be allowed. The section 162 provides that such statements can be used only for the purpose of contradictions. Contradiction means the setting of one statement against another, and not the setting of a statement against nothing at all. An illustration would make the point clear. If a witness in court says, I saw A running away, he may be contradicted under section 162 by his statement to the police, I did not see A running away. But by proving an omission that the land council contradicts is not the statement, I saw A running away, but the statement I stated to the police that I saw A running away, as section 162 doesn't allow the witness to depose. I stated to the police that I saw A running away. It follows that there can be no basis for eliciting the omission. Our argument is further fortified by the use of the word any part of such statement ... may be used to contradict. It is not said that whole statement may be used, but in order to prove an omission, the whole statement has to be used, as has been done in the present case. 43 Miller. The contrary view is expressed in the following proposition. An omission may amount to contradiction if the matter omitted was one which the witness would have been expected to mention, and the sub-inspector to make note of in the ordinary course. Every detail is expected to be noted. Now 44. This proposition, if we may so couched in wide phraseology, enables the trial judge to put into the mouth of a witness things which he did not state to an at an earlier stage and did not intend to say, or purely hypothetical consideration. The same idea in a slightly different language was expressed by uh, Brabograph and Sahi, Justice so and so, the state versus Manumala. There are, however, certain omissions which amount to contradiction and have been treated as such by this court as well as other courts in this country. Those are omissions relating to facts which are expected to be included in the statement before the police by a person who is giving a or narrative of what he saw on the ground that they relate to important feature of the incident about which the deposition is made. Next come to para 50, my lord. No, 49, then 50. Replacing 49. It is not necessary to multiply cases. The two conflicting views may be briefly stated thus. The omission, unless by necessary implication, be deemed to be part of the statement, cannot be used to contradict the statement made in the witness box. 2. They must be in regards to important features of the incident which are expected to be included in the statement made before the police. The first um, proposition not only carries out the intention of the legislature, but it is also in accord with the plain meaning of the words used in the section. The second proposition not only stretches the meaning of the word statement to a breaking point, but also introduces an uncertain element, namely ascertainment of what a particular witness would have stated in the circumstances of a particular case and what the police officer should have recorded. When the section says that the statement is to be used to contradict the subsequent version in the witness box, the proposition brings in by construction what he would have stated to the police within the meaning of the word statement. Such a construction is not permissible. Para 50, my lord. From the foregoing discussion, the following propositions emerge. 1. A statement in writing made by a witness before a police officer in the course of investigation can be used only to contradict his statement in the witness box and for no other purpose. Second, statement not reduced to writing by the police officer cannot be used for contradiction. 3. Though a particular statement is not expressly recorded, a statement that can be deemed to be part of this that expressly recorded can be used for contradiction. Not because it is an omission, strictly so called, but because it is deemed to form part of the recorded statement. Such a fiction is permissible by construction only in the following three cases. When a recital is necessarily implied from the recital or recitals found in the statement. Illustration. In the recorded statement before the police, the witness states that he saw A stabbing B at a particular point of time. But in the witness box, he says that he saw A and C stabbing B at the same point of time. In the statement before the police, the word only can imply it. That is, the witness saw A only stabbing B. Second, a negative aspect of a positive recital in a statement illustration. In the recorded statement before the police, the witness says that a dark man stabbed B, but in a witness box, he says that a fair man stabbed B. The earlier statement must be deemed to contain the recital not only that the culprit was a dark complexion man, but also that he was not a fair complexion. 3. When the statement before the police and that before the court cannot stand together, illustration, the witness, just a minute. The witness says in a recorded statement before the police that A, after stabbing B, ran away by a northern lane. But in court, he says that immediately after stabbing, he ran away towards the southern lane. As he could not have run away immediately after the stabbing, that is, at the same point of time towards the northern lane as well as towards the southern lane. If one statement is true, the other must necessarily be false. 51. The aforesaid examples are not intended to be exhaustive, but only illustrative. The same instance may fall under one or more heads. It is for the trial judge to decide in the each case after comparing the part or parts of the statement recorded by the police with that made in the witness box to give a ruling having regard to the aforesaid principle whether the recital intended to be used for contradiction satisfy the requirement of law.
Any other paragraph of this? This
My lord, para 79.
Hmm.
And 78, then I'm coming 79.
Hmm.
78. This question loses much of its importance when there are patent contradictions and they can be put to the witnesses without any cross-examination, as in the two statements. I saw A hit B. I did not see A hit B. 79. But there are complex situations where the contradiction is most vital and relevant, but is not so patent. There are cases of omissions on a relevant and material point. Let us illustrate our meaning by giving two imaginary statements. 1. When I arrived at the scene, I saw that X was running away, chased by A and B, who caught him. B. When I arrived at the scene, I saw X take out a dagger from his pocket, stab B in his chest, and then take to his heel. He was chased by A and B, who caught him. The two statements are different. 8, my lord. 80. There is an omission of two facts. In the first statement, as A, X took out a dagger from his pocket, and B, he stabbed D in the chest. These two statements or their omission involve a contradiction to the stage of occurrence when the observation of the witness began, my lord. My lord, 86.
That you just skip over. The word contradiction meaning is given.
My lord, then my lord, 87, my lord. We pause to look at the matter from another angle. We shall assume that the interpretation which the state claims should be put upon section 162(1) is correct and compare the respective rights of the accused and the prosecution. According to this interpretation, the accused has no right of cross-examination in respect of the contradiction. This means that no question can be put about the previous statement, but only the part in which there is a contradiction can be brought to the witness notice and his explanation, if any, obtained. In other words, there is only contradictions and no more. But when the accused has used statement to contradict the witness, it may be only on one point. What are the rights of the prosecution? The prosecution can use any part of the statement in re-examination, not only explain to the contradiction, but also to explain any refer to the in cross-examination of the witness matter.
So virtually what you have placed us before, that every omission is not an contradiction. Material omission amounts to contradiction, and the contradiction would be material if the two statements cannot stand together. ଗୋଟେ statement जोटा धर previous statement 161 ହେଇଥିବ ଆଉ court statement ହେଇଥିବ, ଏ ଦିଟା ଯାକ ଯଦି ଏକାଠି ରଖି ହବନି ବା completely contradictory, then that would be material contradiction, and that importance can be attached to that. Every minute thing କୁ ଯଦି ଟିକେ ସେଇଟାକୁ importance ଦିଆଯିବନି, that is what you said. So if that is kept in mind, and whatever
another
contradiction.
thing. Again, one thing, my lord. You cannot put where there is a contradiction in the sentence or the way, you have to put that particular, not that as a whole. In here, my lord, what happened? The contradiction they brought, whatever he has deposed in the para some so and so, he has exactly contradicted everything.
No, that is the fault issue. You cannot put the blame entirely on the defense counsel.
Because
the public prosecutor has a duty to check whether in fact contradictions are there or not. And the court is not the silent spectator. The court is to actively participate. Suppose defense counsel ପଚାରୁଛନ୍ତି ସାକ୍ଷୀକୁ, ଏଇ ଦେଖ ତମ ପୋଲିସ ପାଖରେ ଏଇଆ କହିନ, ତାହେଲେ ଟ୍ରାଏଲ କୋର୍ଟର ଡ୍ୟୁଟି ହଉଛି ଦେଖିବାକୁ ମଧ୍ୟ 161 ଦେଖିବାକୁ, ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ଡ୍ୟୁଟି ହଉଛି ମଧ୍ୟ ଦେଖିବା ପାଇଁ। ଆଉ ଯଦି ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ବାହାରେ ଯାଇକିନି ବୁଲିବ, କୋର୍ଟ ଯଦି ଦେଖିବନି ଯାହା ପାରିଲା ତାହା ଲେଖିଦବ, then you cannot put the blame କାହିଁକି ଏଟା ପଚାରିଲେ, ଏଗୁଡା ସବୁ ଗୁଡାକ ପଚାରିଦେଲେ, that is not the thing. But whatever it may be, when your IO has come, we are again coming to that, when your IO has come and they have tried to prove the contradiction. Now through the IO, whatever they have proved, so if that is stated that those things were not there in the 161.
My lord, one thing again, my lord. The statement what we have read, my lord. One thing they have stated before the IO, my lord. And their statement and the witness box statement, my lord. This particular, there is some contradiction in this statement. Like suppose A and stab B, but now he's saying A and C stab B. So there is again coming the same sentence, but the addition is there. That contradiction is there, my lord.
So far as C is concerned.
C is concerned,
right?
But so far, the my lord, something has not been stated before the IO, which is not there in the statement. He has not written in the 161.
Like he is not at all stated to have seen. Okay.
And that has come later on, my lord.
Yeah.
In the part of 164 or something, my lord. That portion where it will be taken into contradiction or not. It is omission which thereafter illustrated. Because the illustration and extra
somebody has not stated in the 161 statement
exhaustive
that he has not stated before police that I have seen A stabbing B. Making such statement for the first time in court.
That, my lord.
So,
but if there is some that
he has stated that A has stabbed B in the 161. In court, he is stating that A and C stabbed B. So that C is an additional thing, right? So that part, that contradiction would be, so far as C is concerned, contradiction is there. But here is a case, something has been stated for the first time in the 164 as well as in court.
But
so what is that something? Whether it is so material or it is so relevant that both the statement cannot stand together, or it is a subsequently totally a new story has been developed.
That is one part. I am on the first part, my lord. As we are on contradiction part, the 164 statement is concerned, the occurrence day, what happened in the first occurrence place, my lord, regarding the assault part, my lord. If I'll go to the statement of the 161 one and also FIR and the witness deposed, my lord, so that is their consistent, my lord. The small contradictions are there.
To the extent
which is not fatal to the process.
CA ଗୁହାଳକୁ ଆସିବା, there is no contradiction. ଗୁହାଳରେ ତାକୁ ବନ୍ଧା ଯିବା, no contradiction. ଅନ୍ୟ ତିନି ଜଣକୁ ସେଇ ଗୁହାଳରେ ବନ୍ଧା ହୋଇଥିବା, no contradiction. ସେଇ ଗୁହାଳରେ ସେମାନଙ୍କୁ assault ହେଇଛି. କି assault କରିଛି, that's a different. Assault ହେଇଛି, ଏ point ରେ ଆପଣ କହୁଛନ୍ତି contradiction ନାହିଁ. But the manner of assault or who has actually assaulted on which part of the body,
there may is also clarified that I cannot. Again, suppose he has stated before the written in the 164, 161, and my lord in the FIR, my lord, that the injection was injected in his eyes.
That's a different.
Only two things are there, so such type of contradiction should not be taken into care, my lord. And if we go to the 161 statement and the deposition, my lord, there is absolutely no contradiction fatal to the prosecution case to not to believe the truthness of the Pedal 1, my lord. So on that basis, my lord, if we are they're taking that there is and for that sake, my lord, the defendants could not able to shake the witness, and there is the testimony is there, my lord. So the first occurrence, if that the occurrence took place, now the question of pardon is, my lord, on the accused person appellant as per 106, my lord, Evidence Act. Before going to the 106, my lord, I would like to draw, my lord, some judgment, recent judgment, my lord, 2020.
On what point?
On that point, my lord, regarding the bottom of the 106, my lord, and also 164 and also 157 Evidence Act, my lord. 3 points I will explain, my lord.
106, it says burden of proving the fact, especially within knowledge.
Exactly, I am coming.
So, how far, what is the relevancy of this section in the factual scenario of this case?
I am. Para 142, madam.
This Shoma Sundaram.
Malach. Para 140.
paragraph 142 टाको प्लेस କରିବାକୁ ଚାହୁଁଛନ୍ତି ସେଇ ଜାଗାରେ।
May, my lord. Can we
Yeah.
continue tomorrow, my lord? Because it's going to 4. It will take time also.
No, you are just
हाँ,
want to
142
place
तुमको
this particular paragraph.
आगे
So finish it, then we'll.
particular para अन्य नहीं इतने आउ अन्य para भी अच्छी just for 106 it is particular paragraph.
Okay, tomorrow if.
Man.
My lord, I may be pardoned to mention, my lord. The petitioner brother died on 20th, my lord. The brother of the petitioner died on.
No, is it a single judgment matter or division bench?
My lord, single best.
Mention before the DR so that DR can place the file.
Matter was listed before Honorable Justice Didas. Then, on approval of the Chief Justice, he denied to hear the matter, my lord.
ଆପଣ ଡିଆରଙ୍କ ପାଖରେ ଦିଅନ୍ତୁ, ଡିଆର ମେମୋଟା ନେଇ ମୋ ପାଖକୁ ଆସିବେ, ପଚାରିବେ, ମୁଁ ଟାଇମ ଦେଇକିନି କେବେ କଣ କରିବା କଥା କରିବି, ହେଲା?
My lord, 30 ତାରିଖ ତାଙ୍କ 10 କର୍ମ ଅଛି ତ?
ହଁ
30 ତାରିଖ ତାଙ୍କ 10 କର୍ମ ଅଛି।
ଏଇ ତାଙ୍କ ମେମୋଟା ନେଇକି ଇଏ କରିଦିଅ।